예, 저희 행사가 2시
Ladies and gentlemen, we'll be starting at 2 o'clock. So I ask everyone who is outside to please be seated, and everyone that is currently networking to also do so too.
둘.
Test, 1, 2, 3. Test, 1, 2, 3. Test, 1, 2, 3. Test, 1, 2, 3. This is the English channel. We're currently testing the English channel. 1, 2, 3. 1, 2, 3. Testing, 1, 2, 3. English channel, testing. We're currently providing live streaming.
예, 저희 행사를 시작하도록 하겠습니다. 예.
Why don't we start today's session? Hello, everyone. I'm currently Hwang Junhyup, and I'm currently working at Minbyeon, Lawyers for Democratic Society. So thank you very much for everyone making time out of their busy schedule for this important event. So I'll be skipping the national anthem because of time constraints, and we would like to dive into today's forum immediately. So we have 남인순, 서서인교, 소병훈, 서영석인, 김남인, 박희승, and 이인용 that will be sharing their congratulatory remarks immediately. And we also have keynote presentation from 공감. We have Hwang Pil-gyu, then Choi Chong-gyu from law firm One-ok, and then for panelists we have Tanya Won-Sorsen, Lee Sang-hun, Kwon Tae-yoon as panelists, and also a member from the Ministry of Health and Welfare, Choi Jin-sun from the Ministry of Health and Welfare. Now, going on to session 2, we also have a violation on the right to origin and remedies for adoptees. We will have the presentation done by Chun Min-kyung, who is an attorney at Honyul. As panelists, we have Shin Seung-yup, and then a Korean adoptee, Lee Hwan-hee, professor at Sungkyunkwan University, Lee Ye-ji, an attorney at Toksu Law Firm and Ministry of Health and Welfare. So I am very sorry for not being able to call on all of your names because we have a lot of distinguished guests here today. So I will have to immediately go on to congratulatory remarks. So it would be good if we could start Kim Nam-hee immediately because of time constraints. So Kim Nam-hee, please go ahead. Please use the mic.
네, 안녕하십니까.
Hello,
보건복지위원회 소속 광명을 김남희 의원입니다.
My name is
제가 지금 2시부터
Kim Nam-hee from the Democratic
보건복지위원회
Party of
결산 소위가
Korea,
잡혀 있어서
and I'm also
이게
an
끝나고
Uyghur,
바로
source
이동을 해야
for
돼가지고 좀
Gwangwon.
먼저 인사를
I'm a
하게
member of the
되었습니다.
National Assembly,
네,
also a
저는
member
국회
serving the Health and
보건복지위원회에서
Welfare Committee.
해외입양
It is a
관련된
great
정책에
honor for me
대해서
to
계속
join in
관심을
hosting today's
가지고
forum
보고
of the
있고요.
significance task
지난
of TRC's
국정감사에서부터
human rights violation,
사실은
decision
입양
on
기록물
inter-country
관리 부실에 대한
adoption.
문제를
So we've been
제기를 해서
looking at how
지금까지
important it
그
is
상황을 계속
to
체크를 하고
recommend,
있습니다.
the government
해외
issue
입양은
apology and establish
우리나라의 가슴 아픈
countermeasures.
역사고요.
And this is a very
많은 입양인들이 본인의 권리를 보장받지 못하고 국가와 사회의 방치로 인해서 많은 그 피해를 입으셨습니다. 이제라도 진실화해에 위해서
recognized human rights violations, and I hope that even though it's late, the fact that the committee has come up with this kind of decision, it is a step forward. I pledge to stand at the forefront of efforts to restore the rights of inter-country adoption victims. So I'd like to thank everyone to make today's event possible, and I hope that this becomes a platform for meaningful discussion that will be reflected in a lot of policies in the future. Thank you. Yes, I would like to now go to Congresswoman Nam In-soon. She has been a vital role in preparing today's event. Hello, everyone. I'm Nam In-soon, National Assembly member for Songpa, Pyeong, and also a member of the Health Welfare Committee. It's deeply meaningful for me to co-host today's forum, and I know that there are many people, especially our adoptees, that are online right now, so it's really nice to meet everyone. So in March this year, the Truth and Reconciliation Commission acknowledged numerous human rights violations in the process of inter-country adoption and recommended that the state issue an official apology. I know that many people have made today's event possible, the MC actually mentioned them, so I won't mention them because of time constraints, but of course I extend my deepest gratitude. I also want to thank not only the keynote presentation, the professor, and also the different kind of moderators and panelists. It is very extensive today, and that means that a lot of people have contributed to the significance of this decision, and also they have actually added. So about 2 years and 7 months of investigation came up with a decision from the Commission and acknowledged numerous human rights violations and recommended that state issue an official apology. This is the first official recognition of state responsibility for such violations in history of inter-country adoption. So it is significant that it formally acknowledged the harm that was suffered by adoptees, but yet of the 367 applicants, only 56 were responsibly recognized by the state, and many were excluded for the reason of insufficient documentation. But considering that the inter-country adoption itself was built upon falsification, such as fabricated records, identity manipulation, that means that this should never be grounds for denying recognition of harm. Moreover, even after the TRC's decision, adoptees are still being pushed towards state compensation lawsuits, raising fears of secondary victimization. So the state must not evade responsibility. It must take concrete and effective measures to heal the lifelong wounds of adoptees. The official apology must be followed by improvements to adoption information systems, the guarantee of adoptees' right to origin, and remedies for identity falsification, amongst other measures. Institutional reforms are also underway. So currently, which I introduced on July 19th, we have the amendment to the Special Adoption Act and the Act of Inter-Country Adoption. It has took effect for this July, and with this change, adoption procedures will now be managed directly by the state and local governments, shifting away from private agency-led systems. Furthermore, we also have the Hague Convention of Inter-Country Adoption that will be ratified by the Ministry of Health and Welfare that will be entering into force. Under this system, the sending country will determine the child's adoptability. The receiving country will also review adoptive parents, and the family court of the sending country will issue final approval. So greater responsibility and transparency. And in addition, I also introduced an amendment to the Framework Act to the Truth and Reconciliation Commission to expand the scope of the investigations, not only to include social welfare institutions, collective care facilities operated by private bodies, but also cases of human rights violations committed by adoption agencies. This is currently being reviewed, but the results are not out yet. So I will do my utmost best to ensure that this bill is swiftly deliberated, and the National Assembly will continue to reflect and incorporate these discussions into legislative and policy reforms, and we will always prioritize the interest of the child and work tirelessly to strengthen the protection of children's rights. Once again, I sincerely thank everyone for being here today. I wish you health, happiness, and peace. Thank you very much. Thank you very much. We had Congressman Nam In-sun. We would like to go into Seo Yong-kyo, but because he's not here yet, maybe Park Hee-seung is not also here. So maybe can we go to Lee In-yong, chairperson, who is also one of the joint members that has hosted today's event. Hello, everyone. My name is Lee In-yong, the chairperson of ONYUR. I would first like to extend my deepest gratitude to Assembly members Nam In-sun and all the different relevant members that made today's event possible. This forum has been convened to explore the concrete measures to redress following the March 25th decision on the TRC's decision, which recognized human rights violations of 56 inter-country adoption cases. And so we'll be looking at not only the victims' harm, but also the redress that will also be looked at. The Commission's recommendations means that it's not just individual institutions' responsibility, but also constituted the state's responsibility. So it's a very meaningful decision. Yet a decision alone cannot restore the victim's rights. The Commission's recommendations must be implemented, leading to institutional reforms and substantive support. At ONYUR Foundation, we have worked long to advance the rights of the society's most vulnerable, including children, women, the elderly, and persons with disabilities, through legal assistance, policy advocacy, and legislative initiatives. In particular, we have consistently raised the issue of children's rights, including inter-country adoptees' right to roots, both domestically and internationally, also legal remedies such as constitutional petitions and administrative lawsuits. Today's forum was conceived in that same spirit to reflect the direct voices of inter-country adoptees and to design effective measures for their redress. The first presentation will examine the state's responsibilities and the procedures for redress following the TRC's decision. And the second presentation will address violations of adoptees' right to their origin, the related legal and institutional challenges. Both topics call on our society to reflect on the responsibility we bear toward inter-country adoptees and their families. And through this forum, ONYUR hopes that this discussion on the protection of adoptees' rights and the state's duty to provide meaningful redress will take a step forward. And I hope that today's proposals and discussions will not remain on record alone, but will lead to legislative and policy change, becoming a starting point for real improvements to the lives of each and every victim. Once again, I extend my deepest heartfelt thanks to all participants for sharing your time and wisdom and insights here today. Thank you for the welcome remarks. The members of the National Assembly members haven't arrived yet, but due to time constraints, let me introduce the background of today's event. Today, we're gathered here after a long fight, and this fight was fought by the inter-country adoptees themselves with their courage and dedication. The issue of inter-country adoption has finally risen above the surface. I'd like to thank all the inter-country adoptees, and I'd also like to express my deepest respect to them. This is a new path by the inter-country adoptees, and we are trying to find ways to remedy the harms suffered by inter-country adoptees. And the issue was brought by Lisa after her complaint filed, and also the administrative litigation. In the process, she expressed how the issue is so serious, and Juru, the foundation, and also we were sponsored by Omalu, and we got opportunity to protect the inter-country adoption, and we decided to open a forum for the inter-country adoptees, and today's event is to honor that promise. And also the inter-country adoptees who were decided to be remedied by the TRC, and also we'd like to respond to their claims. I hope that this event will help inter-country adoptees and their families and contribute to the recovery of the harms suffered by the adoptees and also their countries. 서영석 and Kim Nam-hee and Park Ki-seung and Nam In-soon, and also Kongam, and also the Foundation of Children and Youth of the Lawyers for a Democratic Society. It's a public interest event. We are going to listen to the welcoming remarks by the members of the National Assembly who haven't arrived yet. And before we start the event, we are going to have a group photo session, so please come up to the stage before we begin the event. Please come up to the stage for the photo taking session. So distinguished guests, if you want to participate in the photo taking session, please come up to the stage, and those panelists and speakers, please come up to the stage so we can take a group photo together.
네, 저희 본 행사를
So let us begin the event. We have Hwang Pil-kyu that will be talking about the significance and tasks of the TRC's decision as the first keynote speech. Everyone, please welcome him to the stage with a big round of applause. Hello, everyone. I think human rights violation caused by inter-country adoption is a global phenomenon. So here, if you think about inaccurate screening of adoptive suitability, falsification of official documents, lack of proper consent from biological parents, excessive financial gain by adoption agencies, often occur with the involvement and acquiescence of the state, and at times lead to child trafficking and enforced disappearances. So during the past few years, through the persistent efforts of inter-country adoptees, several countries have released reports on these problems. Unlawful inter-country adoption has emerged as an international human rights issue. Since 2021, the Netherlands, Denmark, Sweden have published reports, and Norway is expected to issue one later this year. Now, international human rights standards set out the list of rights and crimes implicated in unlawful inter-country adoption. Unlawful inter-country adoption violates the child's best interest, the rights to nationality and identity, the right to family and parental relations. It's not limited just to trafficking and enforced disappearance, but also carries the potential to amount to crimes against humanity and even genocide. International human rights standards also present key principles to prevent unlawful inter-country adoption. Such as the best interest of the child. Second, through the exploration of alternative care options through the... So the standards also present key principles to prevent unlawful inter-country adoptions. First, the best interest of the child. Second, the exploration of alternative care options within the child's country of origin. Third, prevention of improper financial gain. Fourth, the sufficient verification, authorization of competent authorities, verification of qualifications and consents of all parties. So the Truth and Reconciliation Commission's decision this past March on these human rights violations in the inter-country adoption process starkly revealed how tragically these principles were ignored and profoundly undermined. So we can actually summarize the significance of DRC's decision and its related findings. First, it was officially confirmed that unlawful inter-country adoption was a structural outcome of the state's continued abuse of public authority. The TRC, based on past laws and official documents, were confirming the following. The Korea's overseas adoption policy began as a so-called measures for sending mixed-race children abroad. And adoptions policies were shaped not by child welfare, but by economic and political diplomatic objectives. And faulty laws and abandonment of oversight allowed the interests of private adoption agencies to dominate the entire adoption process. Throughout the entire adoption process, numerous human rights violations occurred through various unlawful and improper practices. Now, the second significance of the TRC's decision is that publicly confirmed the widespread and diverse human rights violation across the entire process of adoption. It is important to note that these findings were based solely on the document reviews, so covering just 56 confirmed cases out of 367 applications without compulsory investigative powers. Thus, this means what was revealed this time only represents only the tip of the iceberg. Before adoption proceedings even began, agencies engaged in large financial transactions and negotiations to secure children and meet their adoptive parents' demand, including advertisements about fee discounts to attract clients. At the start of adoption proceedings, records were falsified and procedures were abused so that children of unwed mothers were processed with the consent of unauthorized persons, distinguished as orphans or missing children were reclassified as abandoned. On the adoptive parent side, qualifications were virtually not examined, and they were provided with false and incomplete information and were pressured to make additional donations. At the stage of overseas departure and settlement, in some cases, identities were switched for administrative convenience after a child's death. Domestic agencies did not monitor oversight whether the child acquired nationality in the receiving country. Third significance of the TRC's decision is that it adopted a human rights-based approach, issuing comprehensive recommendations to the state regarding unlawful intercountry adoption. So the state was urged to officially acknowledge wrongdoing and issue an apology to adoptees. The Ministry of Health and Welfare and the Ministry of Foreign Affairs were urged to establish a dedicated investigative body to identify victims of unlawful adoption and the lack of citizenship in receiving countries, and to devise remedies. The Ministry of Health and Welfare was urged to actively collect, preserve, and disclose records held by adoption agencies and other relevant institutions. DNA testing, family unions, and ongoing exchange are just some examples of practical supports that must be given by the state. Despite these points of significance, the TRC's decision does still have limitations. The majority of the cases were suspended from investigation, and some argued that they should be closed for lack of evidence. However, poor record-keeping and oversight themselves constitute a grave violation of the right to truth and identity, and the responsibility should not be shifted onto those victims. And you have to think about the prejudices against inter-country adoption, lack of understanding of its structural dimensions, risk of political distortion, and the influence of adoption agencies appear to have directly or indirectly affected TRC's decision. We are left to continually ask whether the investigation and conclusions were truly sufficient. Why is it that 1/3 of all inter-country adoptees worldwide are from Korea? Have the conclusive ties between related institutions and facilities been adequately investigated? Has the money trail of adoption agencies have properly been traced? Have secondary harms in the process of family searches been sufficiently assessed? And given the gravity of the human rights violations, cannot they be explicitly categorized as enforced disappearance or child trafficking? So beyond these issues and limitations, additional constraints still do exist. The fact that inter-country adoption human rights cases were treated as just one case amongst many in a single department of the TRC means that there are human and material limits, barriers that posed not only by language, but also by political, economic, social, and cultural differences, the absence of enforcement mechanisms of the TRC recommendations, and the structural limitation of the TRC Act, which makes investigation by application the rule and ex officio investigations the exception. Not only that, the most important task going forward is the full realization of the right to truth for the victims of unlawful adoption. The right to truth means knowing the reasons for the violation, such as, and also above all, the scale of the inter-country adoption related to human rights violation. We have to think about their long duration and linguistic cultural differences involved. So I believe that the amended TRC Act should be explicitly including the TRC violations in inter-country adoption as a subject of investigation and provide an inquiry, at least by being an independent subcommittee or division. So that was what Assemblywoman Nam In-soon introduced in the bill to amend the TRC Act, which was significantly meaningful. At the same time, Korea should actively pursue joint investigations with the Netherlands, Denmark, Sweden, and Norway, and assess the problems to the United States. It is also necessary to establish and operate an independent body that will investigate the truth of the entire adoption process. The second task ahead is to ensure adequate and sufficient remedies for victims. So remedy encompasses not just then financial compensation. We should also think about effective steps to end ongoing violations, public acknowledgement, and facts and acceptance of responsibility through a official policy, as well as commemoration and remembrance of the victims. the failure to prosecute perpetrators under law can itself constitute a breach of the state's obligations. We also have to think about the Ministry of Health, Welfare and Health regarding proper record preservation, requiring concrete and effective measures, and the issues of reestablishing identity and family relations arising from findings of unlawful adoptions. So we must handle this on the basis of child's best interest and full participation of the voice of victims, and the criminalization of unlawful adoption and the exclusion of statutes of limitation. Let me give you a summary of what I've just shared. There's no inter-country adoption for the benefit of the child. At every stage of the inter-country adoption process, Korea built what became the world's most efficient system of unlawful adoption, sustained by systematic human rights violations. The state perfected the system through policies guided by diplomatic interest, active admin measures, and negligent oversight. And now, even as parts of this have just come to light, there is still no state that offers either an apology, restoration of rights to the countless victims of inter-country adoption. So we ask, what is the state? If Korea is to be a state, what must the Korean government do for these inter-country adoptees today? Thank you.
I'd like to thank the attorney Hwang Pil-gyu for his keynote presentation. Now we are going to start the session 1, remedies for inter-country adoptees following the TLC decision. So, speakers and panelists, please come up to the stage. The session 1 will begin at 14:30 to 15:40. The moderator, So-Ra-mi, she is a professor at Seoul National University. First of all, law firm Wongo attorney Choi Jung-kyu and Tanja Sorensen, attorney Lee Sang-hoon, attorney Kwon Tae-yoon, and also the secretary from Ministry of Health and Welfare will take part in the panel discussion. The presentation will last for 20 minutes, and each panelist will be given 10 minutes. So, can you please start the presentation? Good afternoon. I'm the moderator of session 1. My name is So-Ra-mi. The attorney Hwang already introduced the background of today's forum. After the TLC's decision, and attorney Hwang briefly overviewed the significance and the details of the decision. But today we're going to touch on the two major topics that the adoptees are most interested in. And during the first session, we are going to talk about the remedies. And during the second session, I believe that the inter-country adoptees are very much interested in the access to their information, their right to know. So we are going to talk about that during the second session. So if you have any questions, we are going to take questions from both online and from the floor. And the first session will be started by attorney Choi Jung-kyu from law firm Wongo. Please give him a big round of applause. So let me start my presentation. On March 25th, the Truth and Reconciliation Commission of Korea rendered a truth-finding decision for 56 inter-country. During the keynote presentation, Attorney Hwang already mentioned that this is not only the responsibility by the adoption agency, but also the Korean government. Framework Act on Clearing Up Past Incidents for Truth and Reconciliation, hereinafter Framework Act, stipulates the state's duty to endeavor to restore victims following a truth-finding decision. It further provides that the head of the government agency responsible for a given recommendation must submit an implementation plan to the Minister of the Interior and Safety in accordance with the relevant procedures. The recommendations contained in the truth-finding decision of the Truth and Reconciliation Commission are not legally binding, as the term recommendation itself implies, but rather urge the state to take action. For this reason, it is important to monitor and manage both the plan formulated by the head of the responsible state agency. From the perspective of remedying the harm suffered by inter-country adopters, the current point in time is as significant as the TRC's decision itself. This is because we are having this forum. While I was preparing this forum, the Ministry of Justice released the press that it is going to withdraw the state's appeals in the state compensation lawsuits filed by the victims of the brothers' home. We have to be happy with this announcement, but at the same time, this is a very grave decision. That is because, as we can see in the Framework Act of the Past Incident Clearance, the Article 34 stipulates that the government have to take action to remedy the victims and make efforts to reconciliate the public. As we see in the Brothers' Home and Songgam Academy cases, we could find three key problems. First, even though the TRC's truth-finding decision and recommendations existed, the government's implementation plan contained no measures for remedy. Second, victims of state violence chose to file new lawsuits against the state in order to seek redress, and this became the only means available for recovery, and there were no alternatives. Third, even when the victims won their cases, the state nevertheless filed appeals against the judgments. The state treated them as their enemy. The problem faced by the victims of the Brothers' Home and Songgam Academy cases are not unique to them. In the Nokwa operation, a program of forced conscription and coerced informant activity, the repatriated abducted fishermen cases, and numerous fabricated espionage cases, victims of state violence waited for the government to prepare remedial measures following truth-finding decisions, but ultimately were compelled to file state compensation lawsuits. In those suits, they suffered secondary victimization, not only from the state's routine appeals, but also from arguments denying the state's liability. This forum is being held to ensure that inter-country adoptees are not forced to resort to litigation and subjected to such secondary victimization in the course of litigation. Through this presentation, I intend to emphasize the roles of the Ministry of Health and Welfare and the Ministry of Justice in formulating remedial measures for the inter-country adoptees that prevent them from being forced into litigation and protect them from further victimization. Then let me touch on how the Ministry of Health and Welfare should implement TRC recommendations for the redress of inter-country adoptees. Inter-country adoptees have suffered grave Harms such as violations of legal identity, unlawful acts in the adoption process, harms relating to nationality, and post-adoption abuse, constituting very serious violations of human rights. These harms go beyond mere administrative errors. They constitute grave infringements on fundamental human rights and personal identity, requiring responsible state-level restorative measures. The process of formulating and finalizing an implementation plan after a truth-finding decision will determine the outcome of that decision. It may remain a mere record without real effect. To ensure that the TRC's work leads to meaningful implementation by state agencies, Article 32-2 of the Framework Act, newly inserted on March 21, 2023, and currently in force, provides that state agencies with jurisdiction over recommendations must respect and make efforts to implement them, while the Minister of the Interior and Safety is tasked with monitoring and managing the status of their implementation. However, the system is not working properly. There have been forced transcription and also forced espionage during the authoritarian regime. It was to prevent college students to take part in student movement, and I will explain how this malfunction has caused secondary victimization for victims. The TRC in 2022, November 22nd, the Truth and Reconciliation Commission issued the findings of truth for 187 victims and over 5 rounds. It has issued findings for a total of 462 victims. The implementation plan submitted by the Minister of National Defense as the head of the government agency responsible for the TRC's recommendations to the Minister of the Interior and Safety pursuant to the relevant laws is as follows. That includes state apology, and also it urges to come up with follow-up measures, and also to prevent human rights violating during military service. It also urges to establish investigation agency, and that was all. After the truth-finding, 3 years after truth-finding decision, not even single one was implemented. The plan should be very detailed and must include a deadline. Without detail and deadline, could not honor the recommendation of the TRC. What's even more unfortunate was that regarding the recommendation implementation plan, the deliberation committee confirmed the plan aforementioned. Within the recommendation system, no improvement or supplements were made to the plan, and the entire process was conducted in strict confidentiality. Victims were not given an opportunity to present their views. Meanwhile, the victims were compelled to file individual lawsuits against the state to seek redress. In these state compensation cases, the defendant, the Republic of Korea, argued for dismissal of the plaintiff's claims, contending that their right to claim state compensation did not exist on the grounds that a TRC decision alone was insufficient to prove the harm suffered, and that their claims were extinguished by the statute of limitation. The court rejected these arguments. However, the victims reported that confronting such assertions from the state during litigation caused them severe emotional distress, comparable to the trauma they had suffered from past state violence. After the truth-finding decision, victims continued to suffer. That was because the implementation plan was properly established. The Minister of the Health and Welfare should have honored the recommendation, and it should have been very detailed. According to administrative legislation, it have to follow the process of notice of disposition, hearing of opinions, submission of opinions, and public hearings. I respectfully request that the plan be disclosed to victims in advance of its submission to the Minister of the Interior and Safety, and that victims be afforded the opportunity to submit their opinions and have those opinions thoroughly considered. And the victims must be heard before the Minister of Health and Welfare make the final decision. And I think they should be given enough time at an appropriate scale event. The redress for inter-country adoptees must go beyond mere monetary compensation by the state. It also requires in-depth discussion on how to restore violations of the right to origin of adoptees. In this presentation, I will focus on the Ministry of Justice's role, particularly from the perspective of monetary compensation in its capacity as the government body responsible for the State Compensation Act. For reference, the TRC issued a policy recommendation on November 29th, calling for legislation to provide comprehensive reparation and compensation for cases. The State Compensation Act provides two avenues for seeking redress: filing a compensation claim with Compensation Deliberation Committee and filing a lawsuit in a court. Compared to the state litigation, the submitting a claim to the relevant Compensation Deliberation Committee can save time and money and energy. It can help them get compensation in a more rapid manner. So I believe that this can be utilized to better help them. And also the State Compensation Act also includes such a provision in Article 16. Victims should not be compelled to state litigation. Instead, they have to take aggressive action to compensate them and remedy the harms done to them. Also, in 2023, the Korea Post informed the public via its internet banking website and written notices of court ruling related to postal savings transactions involving persons under limited guardianship. The notice also informed the affected individuals that they could file state compensation claims for damages arising from such transactions. Following this guidance, the TRC's decision and the competent government body have to inform the victims state compensation system. And the Ministry of Justice, the responsible government body, have to take more active role in this process. And they have withdraw the appeals against the victims of Sangam Academy and the Brothers Home. The Ministry of Justice used state compensation system to better redress the harm suffered by the victims. Only then the victims wouldn't be compelled to file state litigations, and they will be also protected from the secondary harms, and that can also protect their right to be compensated by the state. So it was about the role of Ministry of Health and Welfare and Ministry of Justice after the decision made by TRC. Thank you.
So thank you very much. We have from Wonggok, the Choi Jung-gyu, that shared the remedy measures for inter-country adoptees for the TRC decision. We have Seo Byung-hun, a member of the National Assembly, that is here a bit late. So thank you very much for currently attending today's event, and I have a different appointment at 3 o'clock, so I'm very sad that I can't stay till the very end. But I know that we have all the broadcast station here. It's really important to actually broadcast this, and I know that all the pain of our inter-country adoptees are immense, and you pretty much have endured everything, become adults. And so right now, the state in the TRC decision, despite of the decision, is still silent. So we have Nam In-sun, that is the head of the committee, and also billing all these rights right now. And so the Ministry of Law should also be responsible to come up with concrete actions to solve these actions. I'll be at the forefront for fighting for you. Thank you. Thank you for making time out of your very tight schedule. This was National Assembly members Seo In-gyu, Seo Byung-gyu. And so currently she is at the forefront of passing a lot of bills, and also has reflected this in her congratulatory remarks. And so even if there's a decision in the TRC, it doesn't really redress all the victims of inter-country adoptees, and these also could lead to years and years of lawsuits that could lead to more compensation. Is this also victims' secondary victimization was one of the questions that came up during the presentation. So how can the Ministry of Health and the Ministry of Law work together to make sure that this is a process that is smoother, that also caters to the rights of their adoptees? So we also have our first panelist from Denmark. We have Tanya Wol Sorensen, and so her name is Hwang Tae-kyung. She will be talking about her personal opinion about the TRC's decision, questions, requests that she probably has to the TRC. So please go ahead, Tanya.
Thank you very much. Good afternoon, everyone. My name is Tae-kyung Tanya Inwol Sorensen. I'm very happy to have been invited today to speak as one of the 56 adoptees whose cases have been recognized by the Truth and Reconciliation Commission to have well-documented human rights violations, thus recognizing us as victims of state violence. I would like to share with you what they look like in my case and a couple of thoughts on what should happen now. And since my work is creating and telling stories as a filmmaker, this will be presented in a type of story form. So I hope that's okay with everyone. When you tell a life story, you often start at the beginning. But what if there is no beginning? I grew up believing that my life started when I landed in Denmark. That is what I was told by my adoptive parents, and that is what they were told by the Danish adoption agency. Even the adoption documents corroborate this story. Unknown father, unknown mother, unknown birthplace, everything unknown. In sum, there is no story. What you can deduct from all the unknowns is that I was found and placed in the KSS children's home before being sent to Denmark to start my so-called real story. The question is, why has no one questioned this? Found how? Found by who and where? It was a convenient story for a childless couple to receive a child with no attachments and no story, the closest to having your own child. And the documents show the stamps and approval of all the correspondent authorities in both Denmark and Korea. So why question it? As an adult, with the help and knowledge of other adoptees, not the systems neither in Korea nor in Denmark, I filed a family search through KSS. And it turns out that they did have my mother's contact on file the whole time. So my mother exists. She is alive. But that's all I got. No name, no picture, no address. But I could write her through KSS. And for a short time, we did exchange a couple of letters before she cut all contact. The story is, after she had me, she married and had 2 kids. She's scared that her life will be torn apart, that her family will turn away from her if they find out about me. She is scared and traumatized. Even after all these years, society will not accept her. So we are both victims of this system. Then I filed another family search through KSS. Because if they have my mother's information, they must have more information about me. So what are they not telling me? And again, it was only thanks to the help and knowledge of other adoptees, not the system here in Korea nor in Denmark, that I learned how to apply the exact way so that they had to give me my birth document. Because in the application, all the way down, you have to know to cross out section D, named Other, and you write the name of the document you need with the exact title. KSS did not give information gladly, even though it's our own information. And there, in the Korean birth document, it said birth date, birthplace, birth weight even. Not much, but a little more than what I had before. So, in the official document, I was found in Seoul, and in the secret document, I was born in a midwife clinic in Incheon. To grow up with no beginning affects your sense of self in many ways. But to find out your beginning was erased on purpose to uphold the system shakes your identity in another profound way. I do not have grave and violent circumstances for my beginning, like too many other adoptees have. Instead, my case represents the large majority of all adoptees, and it represents the system's logic. it is from this standpoint that I speak. As one out of hundreds of thousands whose beginnings have been erased and falsified to be sent abroad for another's story. In 1982, when I was born, at the height of the adoption frenzy, hundreds, even thousands of Korean babies were being flown into Denmark alone to be strewn across the country into white Danish families. On my flight, we were at least a dozen small babies, all with the same story of no story, all orphans found on paper. So I will never have a relationship with my mother. It is too late. But even the adoptees who find their families and resume a relationship with them, it will never mend the time and hurt caused by adoption. Us adoptees have known for years and years that our documents were falsified, that our orphan hujuk signed by the authorities were false, that our stories of no stories were fabricated. Because we've been looking for our backgrounds, we've been sharing information and organizing, we've been questioning the official story, and we've met the walls of secrecy and bureaucracy in Korea and the countries we were adopted to. Transnational adoptees have been calling out the Korean transnational adoption system for decades and have been met with silence. So I, and I think many of us, hesitantly welcome the TRC's conclusion. It is the first time in history, in Korea and in any country, to officially acknowledge the human rights violations in the cases of transnational adoptees. But it will be merely symbolic if no legal and political change follows. So I still don't know my mother's name or what she looks like. I don't know anything about my father, and I can't go asking for them because I don't speak the language and I don't know the system. The adoption agencies had our folders with all of our information about our beginnings, but they will not share them with us. And now they're in an abandoned freezer under the jurisdiction of an incapable NCRC. So even now, we are still not able to access our documents or gain any information. Having been sent away under false pretense, having lived a life with false information, having lost access to family, language, culture, history, and being inserted into another family, language, culture, and history does have lifelong consequences. And again, adoptees have been coming back for decades to live here, to search for pieces of the very empty puzzles, and for recognition and justice for what has been done to us. But it should not be up to us to go look and search and demand like strangers in our own country. It should be in the government's own interest to offer compensation, acknowledgement, assistance, and restoration, as recommended by the TRC. So now is the time for reckoning with the past. For the ones you sent away are back and have been back for a long time. And we demand to be recognized, to be compensated, and to have our lost identities restored. The TRC's conclusion to find human rights abuses in only 56 out of hundreds of thousands of cases should only mark the long overdue tip of a legal and political iceberg in Korea for the benefit of all adoptees. So I look forward to hear what will be discussed further on here today. Thank you very much.
Lawmaker Park Hee-seung has just arrived, so we will listen to her welcome remarks. She's going to deliver her congratulatory remarks. Good afternoon. I am Park Ki-seung, member of the National Assembly. Starting from today, I am at the Commission of Health and Welfare. Before, I was in the Justice Commission. And after I make a remarks after the Budget Committee, I'm sorry for being late. Distinguished guests, experts, government officials, and overseas adopters, first of all, I'd like to thank all of you. This past March, the TRC, the Truth and Reconciliation Commission, recognized that the state committed human rights violations in the process of intercountry adoption during the 1970s and 1980s, and recommended that the government issue an apology to the victims and establish measures to prevent recurrence. This marked the first time that the Korean government clearly acknowledged both fundamental rights violations and state responsibility in the history of intercountry adoption. But this decision must be seen not as the end, but as the beginning. Following truth-finding, there must be meaningful restoration and institutional reform. It is unacceptable that victims of past injustices continue to be driven into state compensation lawsuits, only to face the claims of statutes of limitation and deniers of responsibility. The National Assembly recognizes the sorrow suffered by the intercountry adoption. In closing, I express my deep gratitude to the co-hosting and organizing institutions and all those who prepared today's event. I also extend my respect to the presenters and panelists for their dedication. I hope this gathering will serve as a meaningful occasion to illuminate the way forward. Thank you. Thank you, lawmaker Park Ki-seung. To take part in today's event despite your busy schedule. As an intercountry adoptee herself, Ms. Sorensen mentioned that it was state violence on intercountry adopters, and the TRC's decision is only the starting point, and the state have to make an official apology. Next, Attorney Lee Sang-hoon will make his remarks. He's a former standing commissioner of TRC. So as an insider, he's going to provide his view on the issue. Please give him a big round of applause. I am former Standing Commissioner Lee Sang-hoon. TRC have processed over 20,000 cases, and there were only 2 standing commissioners. And I was in charge of inter-country adoptee cases. Although it wasn't enough, there have been a lot of positive feedback on our work. The one thing that I want to add is that the TRC's decision on inter-country adoption cases is that thanks to the hard work made by lawmaker Nam In-soon, now the cases can be covered by the state, and the Special Act on Intercountry Adopters would be implemented, and why I'm going to talk about why it should be addressed as a national and public issue. And I think that is very meaningful. As we were facing various cases, especially inter-country adoption cases, they had uniqueness. However, the public interest on inter-country adoptions has increased, and today I'm going to share my insider view. First of all, let me touch on the limits of the TRC's role as a state's role. First, TRC is an investigation agency on state violence. Korea is a unique country when it comes to state violence because there are not many countries across the world which has a special agency on state violation investigation. However, Korea has one. That is because Korea has a unique history of colonial rule, liberation, division, war, and military regimes. So many countries around the world do not have such many unique cases in series. However, Korea has all these incidents in its history during the relatively short span of time. When it comes to the inter-country adoption, TRC was investigating the case, but TRC is not an investigation dedicated only on the inter-country adoption. It is a state violence investigation agency. However, there was no other agency who can do the investigation, so we conducted investigation on overseas or inter-country adoption. However, the problem was that when you look at page 98, we investigate illegal or unjust authority of the government. But when it comes to overseas adoption, there are receiving countries and sending countries, so was very complicated. However, TRC could only conduct investigation mainly on domestic process of inter-country adoption. As you can find in the middle of at the center of the page, TRC is mainly focusing on state violence. The Korean government used to encourage inter-country adoption. However, it did not give or provide any financial support to adoption agencies. So those private agencies had conflict of interest. Since they did not have government financial support, they had to find a ways to finance themselves. So what they did was they have to send adoptees to overseas in order to finance themselves because they didn't have any other way to make a profit. So they have to get monetary profit as a form of donation by sending those children overseas. During the process, there have been a lot of abuse and a lot of problems. And during the process, the government did not take any role. The jurisdiction and administrative bodies of the government did not take any actions in that process. As earlier mentioned, the Special Act on Adoption, it clearly mentions that the state have to take a role, otherwise there could be a lot of serious consequences. The first limit of our TRC's role was only limited to investigating the government violations part, and the second limit was the lack of representation. If you look at the table, so up until 1994, there have been altogether 141,000 inter-country adoptions, and over 50% of them were sent to the United States. Among 52 cases we investigated, 61% of them were sent to Denmark. That is because when we launched the investigation, the KRG in Denmark applied to the TRC. So the relatively large number of Denmark is not because most of those children were sent to Denmark, but because the agency applied to TRC during the course of our investigation. So the second limitation is lack of representation. Third, I was thinking very much on this issue because the TRC's goal is to investigate the past wrongdoings and violence done by the government. But as we were investigating, what we realized was that, well, when we investigate the past incident, first we have to launch investigation, and after we close the investigation, we have to issue apology. So what's important is apology and make compensation. So it was very hard to find who bears the liability. So we couldn't complete the process, but we were just a stepping stone to the next step. So what we could not decide whether there is a judicial liability or not. So we could not really draw a conclusion regarding judicial liability. And also, when it comes to inter-country adoption, it's not a single case. And this is a litmus paper to decide whether Korea can be a country which respects human rights or not. So, well, usually I do not mention the need for the enactment of the special act. However, when it comes to the inter-country adoption, I emphasize the need for the enactment of the special act. Although many of them have not filed claims, there are many adoptees in Korea and overseas. So if you look at the fifth line from the bottom, there are many overseas adoptees who want to come to Korea, and some want to settle in Korea. So there must be financial support for them. So I believe that there must be comprehensive measure to help them. So I think that was the 10 minutes allotted to me. Thank you for respecting the time.
끼시지 않고 내부자로서 진화의 결정의 의의나 한계에 대해서 잘 말씀해 주신 것 같고요. 이후 이제 특별법 제정에 대해서도 좀 고민이 필요한 것 같습니다. 오늘을 계기로 해서 좀 다양한 논의들을 해나갈 수 있기 바랍니다. 다음 토론자로는 저희가 그
TRC's decision. We have the next panelist. We have Kwon Tae-yoon that is currently going to talk about the committee. He is working on the committees of historical issues and reparation, Minbyeon. And so, how did other cases actually repress and redress those issues and historical problems and reparation, and how we can apply it to this particular case. Please welcome him to the stage. Hello, everyone. Currently, I'm at the Committee of Historical Issues and Reparation at Minbyeon, and I've been working for a democratic society. And I remember when I got the request to talk about the TRC and what are those results and difficulties after the decision of the TRC came out in other cases was pretty much the request that I got as a panelist. And so if you think about TRCs, that usually focuses on the democratic movements, and so what kind of governmental decisions were made and how was reparation done after that done. So it's mostly focused on the 1970s and 80s against the dictatorship in Korea. And so after these decisions were made, so what kind of implementations were given after that? So for intercountry adoption, you have also gotten a second TRC decision. We've been analyzing what happened after that would also be very beneficial for your case. So this was also mentioned in Attorney Choi Jong-gyu's remark, but whenever there is a TRC decision, the victims must file lawsuits one by one, individual lawsuits to seek redress. But so for the case of Hyungjaewon, and if you look at other cases, and then after the TRC decision, and then I've also been representing victims carrying out their reparation after that, and then as an activist, and also as an attorney, I've also seen how they've repaired, but I've rather questioned whether litigation should be the final step in resolving this kind of violence. So from maybe the victim's perspective, it might not be something that you want to hear, but litigation is not the silver bullet. And I also can give a different perspective to not only our members at the National Assembly, and maybe this would be a great platform to talk about different kind of perspectives and what kind of remedy measures were carried out. So these are the limitations and difficulties that I have felt after that. So a lot of the cases in problem seekings, damages through litigation, it seems that they're very unclear standards. So the statute of limitations is not very clear in many cases, and this is not just a problem in Korea, but also this is a problem that a lot of other countries experience. But after these kind of TRC decisions, the statute of limitations is mostly treated as 3 years. So after they have known the decision, then the 3-year statute of limitations starts. But whether it has been implemented like this is also a separate issue, because even after the first TRC, courts have been giving conflictive rulings on the same cases. So 3 to 5 years is usually needed. And so even when victims are recognized, they're not sure whether they can get compensation within this period of time, and they don't know what kind of compensation they can receive. So they are left in the dark for quite a long time. And so if you think about the brother's case, so even if there was a decision that was made, then they say show proof and submit proof that you have actually gotten this harm. And so then in that, so if they're not able to prove that they have been harmed, then they are not sure whether they can get compensation. So there are limitations, and then it's not really the responsibility of the government to actually prove it. It's more on the victims to prove it. So this would also be a burden for the victims if each victim has to file individually for compensation, and this could probably prolong the pain of uncertainty that they will have to experience. So there are definitely limitations about this. And the TRC is also a part of the government, and even if you have received recognition that there has been pain and suffering, how the court calculate compensation for pain and suffering, those kind of standards are inconsistent. And then the victim has to prove whether they can actually prove that they have received pain. So even if the state has acknowledged the harm, the victims are forced again to bear the burden of proof and time and cost. Another difficulty that I saw was that considering that this is individual litigation and lawsuits must be filed under each victim's name, so it's more based on the individual's experience and pain, and then the results could also be very different. And there's also time lag between when you get a decision and when you get compensation. So the state violence is often collective, and then there is a common kind of systematic violence, but the case itself is much more individual. So this fragments the cases and weakens the solidarity amongst victims. And we have to not only get compensation, but make sure that this is not repeated, and there should be reconciliation and prevention. But if we see individual litigation as the only source of remedy, this definitely weakens civil society groups that can support each other in truth fighting, and it only ends with lawsuits and loses the larger goals in the society, such as reconciliation and prevention. So that's why I suggest that a comprehensive compensation scheme should be introduced. So rather than asking and requesting the victims to prove that whether they were actual victims numerous times over and again, the state has already admitted the harm. And then we also should include not only the local government, but also the central government. And if you think about the Brothers Institute case, there's also Busan cities, and they have all the practices and the systems that can really directly support the compensation of the case. So other than just litigation and the compensation that is related to the individual legislation, I think we could also think about the support that the individual victims need, and coming up with systematic support that they actually need in their lives is something that is also really important. And lastly, these are measures beyond damages. This is something that maybe not only the government can do, but also the victims can do. So if you see some compensation after, then you can actually create funds to be more proactive. You could also give medical and educational or build memorials and maybe organize remembrance projects so that we don't forget this has happened, and make sure that the responsibility of the government is educated to the society. So not only the government, of course, is responsible, but making sure that what kind of compensations were made, how the system was improved, this all needs to be reported to make sure that this is shared amongst our society to make sure that this is prevented in the future. Okay, so that's pretty much it for me. Thank you very much.
네, 권태윤.
Thank you, Attorney Kwon Tae-yoon. As you were investigating past incidents, there were limits and tasks we have to carry on in the coming days. Next, we are going to invite Secretary Choi Jin-sun from Ministry of Health and Welfare. During the presentation, TRC's decision, and after the decision, the competent government bodies have to submit implementation plans. Ministry of Health and Welfare and Ministry of Justice are responsible bodies, so we've invited them as our panelists today. So please welcome them with a big round of applause. Good afternoon. I am in charge of inter-country adoption. I am Secretary Choi Jin-sun. First of all, I'd like to express my gratitude for inviting me today. As I am taking part at today's forum, I am truly learning a lot, and a lot of experts gathered here today are sharing their knowledge and experience on each cases and also made a lot of helpful suggestions. So the Ministry of Health and Welfare will reflect them when we establish our plans. And they are truly very good reference. Regarding the TRC decision in March, the items they came up with, the Ministry of Health and Welfare are taking them very seriously. And we've tracked what we are going to do in the coming days. And the TRC will publish a report regarding their investigation, and they are going to share them with each responsible ministries. Regarding the TRC decision, we are going to respect them 100%. And if there are responsibilities and items that we have to implement, we are going to conduct them before the deadline. And we will also listen to the adoptees and their families, and we're going to reflect them wholly on our implementation plan. One thing that I want to share today is that the system was not appropriate in the past. And even in the past, the government were neglecting the issue of inter-country adoption. Lawmaker Nami Soon submitted the inter-country adoption bill, and now it has been implemented. And also, the Special Act has been revised, and the country also will implement the Hague Convention in October. The transparency and the fairness of adoption process will be enhanced by the government. So please trust the Ministry of Health and Welfare, and we are going to improve our work in the future as well. Thank you.
Thank you very much, Choi Jin-sun, Deputy Director of the Adoption System Improvement Team. We also wanted to request a member of the Ministry of Law, but because of other schedules and conflicts, we weren't able to bring in another panelist. But we also want to share what we have discussed during today's forum with them, and then also do a follow-up with them. So I think we have about maybe 10 minutes that is dedicated for the Q&A session. It would be good if we could receive questions from the floor here, or anyone that is currently watching us on YouTube. You can also ask any questions, and someone will read them instead. We also have questions that were received beforehand, so it would be good if we could go through them beforehand while you're thinking what kind of questions you want to ask. If you have any comments or questions, please raise your hand. We'll pass the mic to you. Oh, we have some hands up, but it would be good if you could keep your question compact and make sure you ask your question to a particular panelist. Okay, so we have 2 people, and then we could also go to the questions that were asked beforehand, and then Hwang Jun-hyuk, maybe you could actually ask them.
안녕하세요.
Hello, everyone.
임남이라고
My
합니다.
name is Im
보건복지부에
Nam-i,
질의드리고
and I wanted
싶은데요.
to ask
물론
our member from the Ministry of Health
저희가
this
헤이그
question.
비준을
Yes,
한
so
거나
we have ratified
국제
the
입양,
Hague
국내 입양 다
Convention,
정부의 공공
and then, of course,
체계로 들어간 것은 의미가 있는 일이라고
the
볼 수도
fact
있지만
that
사실 그
the adoption
법이
system is now
시행되는
under
2년
our
사이에 제정되고
governmental
시행되는 사이에
systems, but
국제
during
입양
that 2
관련해서
years until it was
굉장히 많은 해외
ratified,
지형 변화가
I
있지
think there was
않습니까?
like a lot of
일단 수영국들이
change.
우리나라
So this
아이들을
means
더
that
이상
the
이제
receiving
받지 않겠다고
countries
선언했고
have said that they
이
don't receive any
시점에서
Korean
국가가 관리하는 해외 입양을
adoptees
지속하는
anymore.
것이 의미가
So
있는지
should we
아니면 이
maintain
시대에
the
맞춰서
system or not?
국제 입양 자체에
Or
대한
should we say that,
재고를 정부 차원에서 해야 되는 게 아닌가 하는 생각이
should now
들거든요.
be revoked
어떻게
or
생각하시는지
changed?
아직 뭐 헤이그
I'm not-
비준도 안
so right
됐지만
now, although we haven't
사실은
ratified the Hague
이제는 좀
Convention
용도
yet,
폐기된
but it seems
협약이 아닌가 싶습니다.
that this convention
이에
or this
대해서 어떻게
treaty
생각하는지
is
복지부
no
정책
longer
입장을 듣고 싶습니다.
meaningful it seems it's time to revise it or actually eradicate it. So yes. Next question.
예, 아동권리연대 조민호라고 합니다.
So my name is Jo
저도
Min-ho from,
2기에 신청을 했다가
NGO for Child Rights.
진실규명불능 이렇게 나왔던
So I am actually an
2차
adoptee
피해를
that,
당했던
as
피해자이기도
a
합니다.
second victim from the second
오늘
committee,
이상훈
saying
의원님하고
that I don't
최정규
have enough
변호사님하고 권태윤
reports, and so I have
의원님이
권태윤,
좋은 얘기 많이
and I know
해주셨는데
that your presentations
저는
were very
당사자 입장에서
informative.
저는 해외입양인은 아닙니다.
But I'm not
그런데
a adoptee, an
해외입양이
intercountry
될
adoptee, but
뻔했던 것을 두 번
adoptee.
경험 갖고
But
있고
I almost was
저는 이제
sent abroad
안 돼서
twice.
시설에서 집단 수용
But I
시설에서
was
퇴소해서
actually,
퇴소한 게 아니고 탈출해서
not able
나와서
to go,
지금도
but
아직
to
그
an
같은 고통을
inter-country
겪고 있는
adoption, and then I was sent to
사람인데
a
그
facility
지난해
in
2기
Korea,
때
and
사실
then
기대를 좀
I
많이 하고
ran away from the
어느 정도
facility.
한계를
So
좀 갖고
I
했지만
had high expectations for the second TRC decision, but saw that there were a lot
조사를
of
그 할 때
limitations.
한계점을 갖다가
When I
3기
was
때는 좀
looking
보완을
at
좀
the second,
좀 많이 했으면 좋겠습니다. 가장 첫
investigation
번째로
limitation, I
뭐냐면
thought that they would be improved
2기
in
때
the third
저도 결정이
TRC.
이렇게 그
So this is the
나왔고 한데
decision that came out
이유가
during
두
the second,
가지입니다.
and there were two reasons that were
우리 그
emphasized.
한국 그 뭐 법체계 내에서는
So within the
신청주의와
legal, so not only the proof of burden and then the application is the burden of the victim, and this really was surprising, and I thought that didn't make sense. So if you work with these facilities, this is something that happened to a child. So the most vulnerable child who cannot even stand up for himself or voice his opinion. And the fact that you have made that victim responsible to file a suit and find the proof doesn't make sense. It's really hard because you were only a child when that happened to you. So not only is this a violation to human rights, I think I was only 4 years old when I lost my mother in the marketplace, and then right now my name changed and my identity changed, and I don't remember who I was. And the fact that you're trying to ask me to prove who I am to a 4-year-old, that I can't do it. That makes no sense. And so this human right violation happened in various aspects systematically. So please take that into consideration if you're giving the burden of proof to a child. And during the 1970s, for 50 years, this was systematic. So making the litigation individualistic doesn't make sense. Please consider how the victims are just children when this happens, and then how you can actually make it a much more comprehensive litigation is something that I would like to comment on. Okay, thank you. Do we have any other comments or questions? Oh, yes, I see a hand. Currently, the member in green. It would be good if we could also receive other questions.
안녕하세요. 한국말 잘 못했으니까 영어만 쓸게요.
네. 네.
감사합니다. Tanya, I have a question for you. Thank you very much for sharing your story. And I'm very sorry to hear that you've gone through the childhood and adult experience that you have. I'm curious about, having gone through the human rights violations that you've experienced, I'm curious about your experience with the Truth and Reconciliation Commission. Often I find sometimes institutions that are set up to support survivors can sometimes perpetuate further harm, and I'm just curious as to whether you found the Truth and Reconciliation Commission experience to be helpful. Do you have recommendations for improving it, or is it working as adequately as you think, not just for yourself and people in your circumstance, but other survivors in the future who come forward to make complaints?
네, 감사합니다. 그러면 사전 질문 나온 것 중에서 좀
Thank you very much for your questions. Maybe we could go through a few questions that we've received beforehand.
사전 신청을
Before the forum, we received the questions online. And regarding the session 1 topic, there have been a lot of questions regarding the third round of TRC. I think this question can be answered by Attorney Lee Sang-hoon. some cases were suspended, and during the third round of TRC, the question is, are they going to be resumed during the third round? And can they submit additional evidence during the third round of TRC? And also regarding language, many receiving countries were not English-speaking countries, and are there linguistic support during the course of investigation? So those are the questions we received online. So among the questions we've just received, first of all, we are going to listen to Secretary Che, and we'll also listen to Tanya Sorensen, and lastly by Attorney Lee Sang-hoon. I earlier mentioned that the necessity of checking the current system, and the Hague Convention was ratified on 27th of June, and it will be implemented in October. And the Hague Convention is about children being raised by their original family, and next, we can consider the adoptive families within the country, and we have to consider the interest of children as our top priority. Only when we cannot find a suitable family within the country, we can consider inter-country adoption. Also, we want to enhance and promote adoption within the country by building a committee that is in charge of domestic adoption, and experts will launch a committee which will deliberate and also improve the current system. And in order to improve the current system, the country will make continuous effort. I believe that the intention of the question is that maybe the government have to consider the need for the suspension of inter-country adoption, because now Korea is more advanced, so probably there is no need to continue inter-country adoption. So can you elaborate on that? Well, at the moment, we haven't made any final decisions, so I cannot really share any things such as suspension of inter-country adoption. However, as earlier mentioned, we want to promote domestic adoption, and we want to improve domestic legislative and administrative system. So the policy committee will consider them, and regarding the policy, and we are going to also make press release to share the process with the public. And when it comes to the policy direction, if you have any further questions, and since I am a working level officer, there are only certain limits that I can talk about. Currently, the committee is being considered, and we are in the final process of inviting the commission members. So other than the experts who are defined by the law, we will also invite experts who have experiences and expertise in the area of adoption. So sooner rather than later, we are going to finish this process, and we are going to share the result with the public through press release. Now, Ms. Sorensen, can you answer the question?
Thank you for the question. I would like to acknowledge that because of the TRC happened to make its conclusion on the ones who had enough documentation to prove that their documents were falsified, makes my case, for example, and the conclusions in my case very random, because this is a system that was built on erasing, as I mentioned. So I think, as one who has been one of the few who have been acknowledged by the TRC's investigation, there are certain things that I feel that we have the responsibility to do. And these are, just like the TRC's conclusions, also limited to what the political system and the political process allows us to do. And I think there are some people, especially adoptees residing here, who are doing some very important work with the TRC and also for the TRC3. So I consider my role as somebody who's been recognized limited, but within these limitations, I also invite other people to at least try and act on whatever is possible. And I think this comes for not only here in Korea, but also in the countries that we were sent to. So for example, in Denmark, there is being absolutely no work done. So there is a recognition of the TRC's work in Denmark, but it is still on the governmental response is still to wash its own hands. And so I think there is a lot of work forward, but this is one small stepping stone. So I don't know if I can give any recommendations really, but I think it would be to try and play on as many strings as possible, especially for adoptees, because this is what we have. We can be strategic and we can play with the cards that we've been given right now. Thank you.
네, 감사합니다. 네, 이상우 변호사님.
Thank you. And now, Attorney Lee. We have to exercise a lot of strength, but what's the most important is that how we are going to approach the cases of inter-country adoption. What I mean is that when I was in charge of investigation, during the second round of TRC, as earlier mentioned, the second round was just a stepping stone. In many aspects, it was only a stepping stone. I personally hope that lawmaker Nam is having a high hope. However, there are only limited things that she can do at the National Assembly, because the Ministry of Health and Welfare is the competent body. However, the Committee of Health and Welfare are paying very much attention to the issue. However, the Commission of Health and Welfare is not doing much at the National Assembly. So I believe that both the Commission and Committee and the Ministry of Health and Welfare have to take a greater role. And during the third round, we are going to conduct additional investigation. I think that there is not much momentum to build additional committee, and we are investigating only 2% of entire cases, and we haven't investigated in the U.S. yet. So I believe that we have to conduct additional investigation, especially in the United States. So we have to take comprehensive actions, including child right, and the role should be taken by the Ministry of Health and Welfare and the committee at the National Assembly. And I believe that the third round of TRC will again play the role of stepping stone. I have contacted many applicants from the U.S. and they are asking there's anything they can do because they haven't submitted application yet. So although we have only limited human resource and financial resource, we are going through a lot of possibilities what we can do. So during the third round of TRC, we'll be supported by other experts, and we will also review the claims and made by the applicant. During the second round, some of the applicants' cases were suspended. That was asked from the floor, right? If you look at the page 92, the conclusion was written by myself. It was revised so many times because there are people who should take responsibility. So we were arguing who should take responsibility, and if we decided who should take responsibility and whether we have to include them in our conclusion. So even if not unconstitutional or formally unlawful, it was nonetheless a grossly unjust exercise of public authority. So I believe that we have to do that, and even like a partial passage would take significance. So we only investigated 56 cases. We could not investigate the remaining cases, but I expected there would be third round. We only have 4 investigators, and the time was limited and the resources were limited during the second round. But if we are supported with more resources, I believe that during the third round, we can process more cases. And during the process, I believe that the government responsibility will become more clear. And that's what I can say for now.
So thank you very much for the active participation in the first Q&A session. And whenever our inter-country adoptees are applying for the TRC, so what kind of results will come out is something that is really difficult for not only me to predict, but the fact that we've actually come up with a decision. And a lot of applicants, the majority were actually from Denmark, and their cases were actually accepted. And the fact that you've actually opened up your stories, really voiced your opinions, and despite the limitations and the difficulties to access your information, yes, I do believe that there was some meaningful progress, although it could have been larger. So what kind of direction do we want to go for the third commission? How are we going to also redress the damage of other victims? I think it should be a bigger movement now. So include more adoptees, and then we also have other National Assembly members that are currently supporting our cause. And then so we have a lot of more organized communities amongst adoptees. Therefore, I believe I'm very optimistic about the third commission. So we have one more hand. Is this a comment or a question? But we also have a Q&A session on the second session, and we're kind of behind time. So there is another opportunity to actually ask questions, so please stay till the very end. Okay. So we've exceeded 10 minutes, but okay, please ask your question, and then we'll go on to the break.
So this is more focused at the TRC, Attorney Lee. as you said, that the U.S. is underrepresented, but I think it's because adoptees are not disinterested in this, but because currently our administration right now is trying to denaturalize or take away citizenship from immigrants in the U.S. And because of the DHS policy, they can revoke our naturalization because of the fraud that's found in our documents. So I think that's the main focus why the U.S. adoptees were not interested or not submitting their applications at this time, is because of the Trump administration.
네, 감사합니다.
Thank you very much for your comment. Another hands up.
Hi, I'm Mita Ree from the U.S. as well, and I want to follow up on what John was talking about. I'm in a very privileged position because I have my paperwork from the late 90s that I received from the adoption agency. Many adoptees now who are trying to get their information with a Freedom of Information Act are unfortunately receiving their documents completely redacted. So my question, I guess, is because I have also received my paperwork from the NCRC with a lot of information that has been omitted, which was very disappointing. So I'm not really sure if it was the agency or if it was the NCRC that decided to omit my birth narrative. But my question then is towards Choi Jin-sun from the National Health and Welfare Department. How will you make sure that the NCRC is going to be preserving our documents before, during, and after the transfer, and to make sure that we will be able to receive everything that the agencies, whether or not they're actually giving them voluntarily or if they're trying to hide them, how are you going to make sure that those documents are preserved and that adoptees will be able to have access to them? Thank you very much.
This is also a question that is mentioned in the second session, but maybe Choi Jin-sun can actually answer this question immediately. So currently, about showing information and then support for intercountry adoption, we have actually the expert here on the second session. So that Ministry of Health actually member can actually answer your question much more in depth. So Hyun Soe will also be mentioning or answering that question. Don't forget that part. And then we'll go on to our break if that's okay with everyone. I know that you have a lot of questions. Please participate in our second Q&A session. We also have a general discussion session from 5 to 5:30. Thank you, everyone. Thank you, everyone, for attending. So we have exceeded our schedule by 15 minutes. We'll just have a 5-minute break, and then we'll resume at 4 o'clock, everyone.
고생했습니다. 네. 감사해요. 네.
예, 저희 그 시간이 다 되어서요. 장례 정리를 위해서 자리에 좀 앉아주시길 부탁드리겠습니다. 저희가 시간이 좀 많이 지연이 된 관계로 4시에 시작을 해야 될 것 같습니다. 예, 자리에 앉아주시길 부탁드립니다.
We'll have to resume very shortly. Everyone, please be seated.
예, 저희 예, 알겠습니다. 저희 행사 진행을 해야 돼서.
We'll be resuming very shortly. Now, we'll be starting session 2. Please be seated. We have exceeded the given time. So second session is about the violation of the rights to origin and remedies for adoptees. We currently have from Sungkyunkwan University as the moderator Hyun So-hae, Professor Hyun So-hae. We also have from the presenter, Attorney Chun Min-kyung from Unyul, the status and challenges and violations of adoptive right to origin. And for panelists, we have Shin Seung-yup, who is a Korean adoptee, that will be given 10 minutes. We also have Lee Hwang-hee, professor at Sungkyunkwan University School of Law, and then Im Ye-ji, attorney from Doksu. And then we also have Chung Yun-chung, deputy director from the adoption system from the Ministry of Health and Welfare. So why don't we go on to session 2. Hello, everyone. This is the moderator, Hyun So-hae, for session 2. And session 2 will be focused on the right to origin and the remedies for adoptees and how we can improve those violations. So because of time constraints, I would like to go immediately to the presentation. We have Unyul, Chun Min-kyung attorney, that will be talking about the violation of adoptees' rights to origin. Hello, everyone. My name is Chun Min-kyung from Unyul. My dissertation is based on the right to know about their origin and Unmal project. And we had cases that were investigating for Denmark adoptees and the comparison law between those different cases. And the English version is also in the YouTube channel. So please download it and read it thoroughly later on. So this is how my paper is organized. I would like to go into the introduction immediately. Since the Korean War, Korea has carried out large-scale inter-country adoptions. As a result, many adoptees grew up cut off from their biological origins. When they return as adults seeking information about their birth, the law blocks them, saying that this information is personal data of their birth parents. Even if the parents are dead, the adoptees cannot get their records unless there's a special reason, such as medical needs. And it's not just about data access. It's also about human dignity and identity. So other than this conversation, the reality of this is not just limited to the personal rights and personal data of their birth parents, but it's also about human dignity and identity that is pretty much at the root of your human rights. So through this paper, I want to explain 3 things: the concept of right to origin, so understanding who I am and also recovering that if that is infringed upon, so language, and then how to think about the different kind of ancestors, language, and culture. And then it's more than just access to biological data. It's also about the right that forms the basis of self-identity and personality. So many adoptees should be able to access. So we're analyzing this from a international convention perspective and how these rights have been violated, what the legal issues are. So now going on to the right to know one's origin, which means the right to know information about one's biological parents' genetic data and birth background. So the scholar Ravitsky explained that even if this right is limited to genetics, it still includes three parts. First of all, the right to know the medical history of the whole family and the genetic data that might affect their health. The right to personal stories from birth parents so that the child can form their identity. Third, the right to know the identity of birth parents and to form a relationship with them. So this means that the right is more than just knowing who their parents are. It also includes building identity through their stories and restoring the parent-child connection. Understanding who they are and where they come from. Now, going on to the UN Convention on the Rights of the Child, CRC, Article 7, children must be registered at birth, have a name, a nationality, and as far as possible, know and be cared for by their parents. And this is Article 7, so this means that they need to be stably provided for to grow and then also to give an identity. They also guide other rights such as no separation from their parents, which is Article 9, family reunification, Article 10, and their parents' duty to care for them, Article 18 and 27th. And Article 7, Article 7 also gives states a duty. They guarantee these rights under domestic and international law. Every child has the right to know their parents, and the state has a duty to ensure that the child will have this information through birth registration. Going on to right to identity. So identitas, the Latin word, is actually at the core of identity. It means that the unique traits that makes one person or group different from others. So to have identity means to have unique and original traits. For an individual, it means being a distinct person in a society. And the identity has two parts, according to Fernandez Sergaso. So it could have static elements such as your name, nationality, birth data, and family ties. Dynamic elements such as cultural, language, and social belonging. So it's a combination of static and dynamic elements. The right to identity is broad, and it includes both changeable aspects and permanent ones. And this right naturally includes the right to know one's biological roots. And the CRC Article 8 also protects the child's right to preserve identity, and this names nationality, name, and family ties. And in the second part of Article 8, this makes the states responsible to make sure that they prevent unlawful loss of identity. This includes their sealed birth records and adoption, and adoptees denied access to birth parent information, and birth parents denied information to find their adopted child. So Article 7 is about the right to know their origin, and the broader right to identify is Article 8. So making sure that if the record exists, hiding them by law or policy is an excessive violation. So this, in short, the right to know includes three things: to know one's birth parents and birth circumstances, which is CRC Article 7, and also to not be unlawfully deprived of their identity, which is parents, family, language, cultural background, and Article 8, and to restore their lost identity and demand the state to provide support for that. So how to redress that damage in Article 8. So it's a very comprehensive right. When we have litigated the right to origin was considered as a constitutional right. So although it's not specified in our Korean constitution, we do have Article 10 that guarantees human dignity and the right to pursue happiness, Article 17 that protects privacy, and Article 36 that protects marriage and family life. So together, this means every person has the right to form and develop their identity. So if you think about birth, parents, family records are core to identity. The right to origin is a part of this that can be protected by Article 10 of our Korean Constitution. And they can also not be, you think about Article 17 to protect their privacy and also protect their marriage and family life. So the right to origin must be considered as a constitutional right, and then dignity, happiness, and privacy and family law. And the state has a constitutional duty, and an individual should not be divided from the family. And if they are divided, it is important to make sure that they can have access to personal information so that they can be reconnected to their family. So the right to origin. So they probably, this is very accessible and visible when they're asking for personal information. But if you think about the different laws or rights that are infringed, it's not limited to this. Making sure they actually have ways to recover this, get support of this. It's a very comprehensive system to actually help them get this. So if the Constitutional Court has cases to the right to origin in 37, although this should also be considered as a constitutional right, although it's not specifically identified. So this is also really closely connected to the court to identity. And although this is not specified in a particular article, if an adoptee is trying to find their parents, and then it is also infringing their constitutional right to know their identity. And their right to origin is not only about the right to know, but it's also about recovering this. And the UNCRC, Article 8, so making sure the country has the obligation to protect this, and then access to their birth data, and then recovering their relationship with their family is considered as a constitutional right. Going on to one of our adoption laws that was revised in 2011 with a special adoption right. So there were some changes by the revision, and there were it was actually revised to protect the right to origin. So but there were deep limits in protecting the right to origin. And the Article 36 of the former Special Adoption Law and Article 33 of the Special Act Law stipulates the adoptee's right to request disclosure of information, but it also had structural limitations because it was based on the consent of the biological parents. So even if they have died, they need medical purposes to actually have access to this information. So the protection of the biological parent personal information takes precedence over the adoptee's right to identity. So going on to the status of adoption of information of disclosure request. So you can see that they can actually ask the adoption agencies and NCRC for their information and request disclosures. So you can see, find where they are, and then the letters to send to biological parents. If they give their confirmed consent, then they get complete information provided if their biological parents consent, and only partial information is provided if the consent is refused. And they need special circumstances such as medical reasons if their biological parents have died. So right now you can see there have been a total of 20,000 or 120 information disclosure requests that have been received until now and only about 18% of those cases have received disclosure of biological parents. So the majority, more than 82% of people, do not have any information of other biological parents. This is because they do not receive consent, and this is against their fundamental right to know who they are. There's also a difficulty in locating their birth parents. So amongst the 2,043 requests, only about 53% were able to identify their biological parents. And then this was for 2022. And then in 2023, you can see that amongst only about 53% of the 2,700 requests were able to identify the biological parents. There's also an absence of resident registration number. That is also a difficulty to determine their current address. So the NCRC can only search for your information through the admin information sharing network. Without a residential registration number, location tracking is limited, and if their address is incomplete, is also impossible to identify their adoptee location. And even if we have the address, if they haven't lived there, the registered mail will be returned and there will be no response. So if there's no response, then the procedure will be ended. And the fact we don't have any other methods to respond to this. The legal interpretation of non-response is also problematic. So even though a non-response cannot be considered as a refusal, according to law, in practice it is treated as the same as a refusal of consent. And if you look at Article 33 of the Special Act of Domestic Adoption, it excludes biological parent information even when the consent cannot be confirmed. So the interpretation extends beyond the active expression of refusal by the biological parents to lack of response, thereby restricting adoptees' rights. And then we also have a problem with the current notice. So even if there's insufficient content of the notification of consent, the current notice only briefly addresses the adoptee request for information disclosure and asks for consent. The structure makes it very difficult for biological parents to fully understand the meaning and the importance of information disclosure, and there is insufficient explanation of the importance of information to adoptees. There's also an ineffective exception provisions. There are a problem of double requirements according to Article 36 of the disclosure of the information in cases where the biological parents are deceased, are unable to consent, or where there are special circumstances such as medical purposes. This is an and requirement which requires both conditions to be met simultaneously and is very strict. So even in emergency situations, these information is very difficult to obtain, even if it's involving genetic diseases. Now, going on to the law, when it went in effect in 2013, not a single case has been disclosed under Article 36. According to the Ministry of Health and Welfare's response, there has been no cases where the exception clause has been applied. So this means that the exception clause is merely a formality with no effect. And there's no clear standards or scope for special reasons such as medical purposes are provided in the It's really difficult to predict when the exceptions may be granted, and if it's like a serious genetic disorder or a life-threatening illness, even in these urgent cases, there were some cases where information disclosure was denied. Now, going on to restrictions on disclosure about deceased biological parents' information, there has been restricted access to deceased personal information, and there's only an exception clause. So this means that the adoptee's access to information is restricted, and the adoptee's right to identify and verification is given less priority than the privacy of the deceased. So privacy, even though they have died, and this has decreased significantly, the balance between the rights of the biological parents and adoptees is severely distorted. Going on to limitations on the scope and format of disclosed information. So limited information subject to disclosure through an enumeration-based approach, and the scope of information adoptees should be known, arbitrarily limited by law. And this is more of a summarized version rather than the actual information. So it's really hard for adoptees to understand the background of why this happened, and they do not have the full context surrounding their information. And it's very contextual elements necessary to verify the legitimacy of the adoption process, such as document format, and then this leads to more uncertainty. So if the original document is not provided, it's really difficult because they have limited access to only summaries. And this leads to the inability to verify authenticity and completeness of the document, leading to more increased anxiety about the possibility of missing the information. And so we've been thinking about how we can improve these tasks and policy and suggestions. So we can actually shift the transition from a birth parent consent-based information to a disclosure structure to an adoptee-centered rights-based based approach. So rather than getting the consent of the birth parent, it's more of a disclosed structure to a adoptee-centered rights-based approach. And we must, of course, consider that non-response is not considered as a refusal, and we also should expand the scope of information disclosure. This should not be just limited to medical information. We also have to include key documents such as adoption consent forms, and expanded scope to include documents related to the entire adoption process. So we also need to have access to viewing and copying the original documents, not just excerpts. And then we've seen the limitations because of the lack of resources. There are other reasons. We can use other methods to make sure that we have access to the original documents. Translation should also be mandatory, provided to the language of the adoptee. And we also need to have the expanding the number of adoptee information of disclosure officers, and we can also have all the reports from the pre-adoption stages. So this is information that is vital to understand the context of the child's life, and we also should have more integrated records management for local government records. And not only the documents, we also need to think about follow-up support systems such as counseling support and legal support systems. So including the disclosure of adoption information and compensation for human rights violation is difficult for just a mere individual to apply for. So that's why we need more legal support from specialized legal experts. Family reunion support such as biological family search program, and then support for for DNA testing and database construction is also needed so that we can actually have, in order to do that, strengthening national responsibility by creating a dedicated specialized organization can be possible. My conclusion is that adoptees' rights to their roots is a core fundamental right for ensuring human dignity. It's also an essential element for establishing identity and restoring meaning in life. The state has a responsibility to restore origins it has deprived, so legal, institutional, and policy efforts are needed to ensure the substantive protection of adoptees' rights. Thank you very much.
Attorney Jen, thank you for your presentation. She's an expert in child and youth rights. So she shared her expertise and experiences in the area and also the issues of information disclosure and the current law, Korean adoption legislation. And next we are going to start the discussion. Our first panelist is Shin Seung-yup from NLKRG.
Distinguished members of the National Assembly, honored organizers, dear fellow adoptees, families, allies, and friends, my name is Shin Seung-yup. Today I sit before you not only as an individual, but as someone whose life, whose history has been bound together with so many others at this moment. I am one of the 556 confirmed cases. My adoption case has been recognized by the Truth and Reconciliation Commission as a violation of my human rights. I speak not only for myself, but alongside my fellow Korean adoptees scattered across continents, as well as those who have stood beside us as we fought for justice, often against the tide. On March 26, 2025, the Truth and Reconciliation Commission took a historic step. After years of careful independent investigation, it concluded that the Korean government bears responsibility for human rights violations in the inter-country adoption system. Out of 375 cases investigated, 56 were found to involve serious violations of fundamental human rights, and the majority of the cases, 311, are still waiting a decision. Let's not downplay the gravity of this moment. These were not isolated errors, not minor bureaucratic mistakes. They were systematic practices that separated children from parents, erased identities, and condemned generations to a life of silence, shame, and erasure. For the first time in history, this injustice has been acknowledged. The truth is no longer buried in sealed files. It is now in the open. I know what it means to live with a name that was never truly mine, to own a passport that tells a story of who I was supposed to become, not who I really was. Adoption gave me a life, but it was not my life. It was a life built on silence, erasure, and bureaucratic fiction. And now we know I am not alone in this. We were taught to be grateful, to stay quiet, to not ask too many questions. But today we break that silence. Today we ask, we demand truth, recognition, and repair. Make no mistake, this was not handed to us. What you see today, this report, these recommendations, this forum, is the result of decades of struggle. Adult adoptees from Seoul to Stockholm, New York to Amsterdam have been fighting, filing complaints, writing, lobbying, speaking up, and refusing to be silent. We kept requesting files that remained sealed. We kept searching for families we were told could not be found. We held governments accountable. We studied laws and we built networks. What once was individual grief has become collective strength. We stand at a turning point. For the first time, we have an official report that states this system violated human rights. For the first time, The government is being held to account, not just the agencies and the intermediaries. And for the first time, the international community is forced to listen. Together, we are ready to contribute to real structural change, because this is not just about Korea, not just about the past. This is about what kind of world we want to build. A world where children have rights, not just paperwork with white parts. A world where origin is respected and not erased. The TRC's findings make it clear. Adoption, as it was practiced, violated our right to origin. The right to know, preserve and restore our biological roots and identity. Under international human rights law, Articles 7 and 8 of the UN Convention on the Rights of the Child, it states, children have the right to a name, a nationality, and to know and be cared for by their parents. States have an obligation to protect the child's identity, family relations, language, culture, and to prevent its unlawful deprivation. The right to origin is not limited to knowing names on paper. It also includes a medical dimension, access to full family medical history, the identity dimension, knowing the personal story of one's parents to shape one's own sense of self, and the relational dimension, the ability to meet, know, and maintain contact with one's family. For adoptees, this right is fundamental to human dignity, autonomy, and self-determination. Yet, in Korea, Korea's laws and institutions continue to deny this right. From 2013 to 2024, over 80% of adoptee requests for disclosure of birth parent information to the NCSC and private agencies were denied or resulted only in partial information. Why? Because consent could not be confirmed, as was just reported. No response is treated as refusal. Or even when parents are deceased, disclosure is limited to narrow medical necessity exceptions. And in more than a decade, only a handful of cases have been improved under that clause. Even when disclosure is granted, adoptees are given only filtered extracts, never the original documents, stripping away crucial contacts such as dates, signatures, and procedural details. These omissions make it impossible to fully verify lawfulness or authenticity of our adoptions. By hiding behind privacy regulations and arbitrary policies, agencies have blocked access to invaluable intake information. So adoptees never knew who signed their adoption papers and how their adoption came to be. This system was not just a legal failure, it was an industry. And the violence of denying full access of one's own adoption files continues to this day. Korean adoption agencies and intermediaries operated as the gatekeepers of our histories, controlling access to families, identities, and records. And over decades, these institutions received billions of US dollars from foreign governments and adoptive families, turning human lives into a revenue stream. The cost of an adoption was not just financial. It was paid in broken families, stolen identities, and the permanent displacement of tens of thousands of children. While these agencies justified their work as humanitarian, the scale of profit exposes a different reality. A market that treated children as export goods, as luggage, and origins as negotiable commodities. The TRC's findings demand that this financial legacy be examined alongside the human cost. But we must also take a hard look at the structures that allowed this to happen. The Hague Adoption Convention has long been presented as the solution to adoption malpractice. But let us be honest, this treaty, written without the voices of adoptees, was not created for us. It protects adoptive parents. It protects sending and receiving states. But it says very little about the rights of the adopted child, especially after adoption. There is no binding right to access your own adoption file, no obligation for post-adoption care, no mechanism to enforce our right to know where we come from. That must change. Some might say, but you found your family and you have a good relationship with them, so the system worked for you. That is not true. The system did not reunite me with my family, I had to fight for that myself. The system concealed the truth for years, even when the information was right there in the file. This is why the right to origin is not a private curiosity. It is a matter of dignity, autonomy, and justice. When the state has taken away a person's roots, it must take responsibility for restoring them. Today, I have the privilege of speaking to amplify the voices of adoptees all over the world who were wronged, but who have become activists, researchers, artists, legislators, and bridge builders. And also the voice of allies, of families, lawyers, and advocates who listened instead of speaking over us, who gave us space, not pity, who stayed, even when it was hard. Together, we stand for something greater than compensation. We stand for dignity, for the fundamental human dignity that no one should ever lose, regardless of where they were born or where they were sent. The TRC's findings give us foundation for action. Make disclosure the rule and non-disclosure the exception, regardless of whether the parents are deceased or whether there's a medical emergency. Give adoptees original, unredacted records in English and Korean, not filtered extracts. Expand adoption records to include all documents from before, during, and after the adoption. Guarantee post-disclosure support, counseling, legal help, and reunion services. Recognize the right to origin as an independent constitutional right in Korea. For the TRC3 to be successful, the government should take the correct actions on preserving all our documents. I end with this call. Let us move beyond legal liability and speak of moral responsibility. Let us recognize that every person is born with the right to know who they are, and no system should ever take that away. This forum is not the end. It is a beginning of dialogue, of repair, of rewriting history that was hidden too long. Because what happened to us was not fate. It was a decision. And what we do now, that too is a decision. We are still waiting for a response from the TRC reports. After the acknowledgement of wrongdoing, after the truth-telling, we need to move towards repair and reparation. Without actions, the results of the TRC are just a hollow acknowledgement of historic wrongdoing that stays as a mark of shame on Korea and its history. But this is not only history. We are still living, and our children will continue to carry on the legacy and scars of this adoption policy. As such, a swift and comprehensive response needs to be implemented. A clear timeline of how the current administration plans to change policy in line with the restoration of dignity and identity for adoptees is needed. We are waiting for an answer and hope this forum is a continuation of the push towards justice for adoptees. Last year, 2024, South Korea was the supplier of 58 children to the global adoption industry. 58 children were sent abroad, continuing the long history of human rights violation and deprivation of their right to origin. This August, the Ministry of Health and Welfare released their guidelines on inter-country adoption for prospective adoptive parents applying for inter-country adoption to Korea. Thus, knowing that South Korea will now continue this practice of human rights violations understates this supervision. And all that while the birth rate is the lowest of all OECD countries. How can the South Korean government continue this practice during this time of existential emergency? If the Korean government continues sending away children to other countries, how is that different from saying that they do not have the capacity to take care of their own citizens? It is 2025, 72 years after Korea started exporting away their responsibility to take care of their children to other countries, violating their basic human rights. Now, let us create a world where no one ever again has to say, I was given a life that was never mine. Thank you.
감사합니다.
Thank you very much. We have Shin Seung-yup that has currently received recognition as a victim by the TRC and also shared his personal experience about how we can improve the current system. So it was a very important session and remark. So I ask for your understanding if we exceeded the 10-minute. We also now go on to go to the second panelist, Professor Lee Hwang-hee. Hello, everyone. My name is Lee Hwang-hee, and I'm currently teaching at Sungkyunkwan University School of Law. So as a panelist, they asked me to talk about a constitutional law perspective about this particular issue. But I think the presenter, Chun Min-kyung, had already talked very extensively about why it should be protected as a constitutional right. So I was thinking about where are the holes, where are the areas that I can improve this currently. So I remember it was the Special Act, Article 37, and the constitutional litigation that is currently being prepared is something that I would also like to add my 10 cents on. So that's where my paper is focused on. And I know that we have a lot of congressmen here with us, but how to solve a constitutional problem is really here, your job, legislation. And if you have ever been to a National Assembly event, sometimes so when they talk about constitutional court problems, I think the legislative branch can actually have more initiative, more of a direct impact. So you can solve the problem much more easily compared to what the constitutional courts. And I would like to talk about the problematic approach that was mentioned by our presenter, Chun Min-kyung, and I really agree this, but it seems like the phrase right to origin seems rather metaphorical, a bit vague and different from other constitutional rights. It usually differs from usual naming of fundamental rights. Maybe is there a better direct term? I did some ideation based on this. Maybe right to birth, right to parentage were some of the suggestions that I came up with. Second of all, the main legal problem is the Special Act on Domestic Adoption, right? And then Article 33, phrase 2, requires parental consent to disclose adoption records, right? So this definitely violates the principle of proportionality. So it blocks the disclosure if the parents died without consent. And we must ask, what interests do these rules try to protect? If it's a public interest, then it's a public versus private conflict. If it's a private, then like privacy, then it's a private conflict. In both cases, proportionality should apply. So principle of proportionality should definitely apply. And you can actually, if it's a public-private conflict and versus private conflict, what kind of proportionality principles should be applied and what the process is different. So yes, I think that the government is more where they restrict our rights, and it's so if you think about Kashmit, you probably have seen this about suitability, necessity, and proportional stricto sensus. So think about these different principles. So being least restrictive is really important if you're going to restrict it, and legislators probably know this more in rut. Least restriction test is something that is really important for public versus private conflicts. But if it's a private versus private conflict, then the least restrictive test is often skipped or weakened, and so this is something that is very different according to the constitutional cases that we currently see. So I would like to maybe use the abortion ban 2017 Honba 127 case as an example. It did not frame as a direct clash between the women's self-determination versus a fetus right to life. Instead, it said that the restriction was to protect the objective value of a fetal life. So it was treated as a public versus private issue or a conflict, not a private versus private. So there is more of a public interest that needs to be protected over a private matter. So this shows how this depends on framing. So what kind of approach do you want to take will be very important when this is considered as a constitutional review. So if it's framed as a public-private, then in the case, it's really important to think about proportionality. And even if that's the case, I think if we have to think it as a private issue, we have to argue that the right to origin ranks higher than the parental privacy. And the right to origin is a constitutional right, and then if this is considered as a public, and it's more of a higher priority, then the court will probably have to review it in a much more restrictive manner. And if the Constitutional Court considers it as a very right versus right, a very common right, then maybe refer to 155, paragraph 3. If you go to the sixth line, if we can't say that one is more of a priority, then we have to make sure to come up with a most harmonious solution where both rights must function. And sacrificing one entirely for the other is not allowed under the Constitution. So if you look at the last sentence, this is something that needs to be deleted. I ask for understanding. It's not directly related to this. And so making sure that we have a harmonious solution between when we have two conflicting rights, both rights must function, and sacrificing one entirely for the other is not allowed. So this is when the principle of proportionality is not, it's exceptionally allowed. So I know that the presenter also talked about this in page 56 from line 3. If there's like a direct right, consent or a non-consent, and this is a very vague area, this would be something that would be considered something really against the adoptee's right, sacrificing one right unilaterally for the sake of the other. So it cannot be tolerated under the Constitution. So this is not really proportionately protecting the both, and this is against what the Constitution is currently going for. So this is definitely a violation against what the Constitution exists. So making sure that we have a harmonious solution between the two rights, sacrificing one entirely for the other, is what is happening in the case of the privacy of the birth parents versus the right to get information from the adoptee's perspective. So definitely you have grounds to file for a constitutional lawsuit. So the next slide is something that you can skim through. I do want to make this point before I end my presentation. I remember that there is also a conversation or an event for other comparisons for other country laws, and this would be very useful for everyone. Please attend.
Thank you for the discussion. So he is a former constitutional law researcher, and he went over the violation of Constitution. So he also touched on the strategic approach. Next, Attorney Im Ye-ji from Daksu will conduct her discussion. Please limit your discussion in 10 minutes.
Practicing in Korea, I have been engaged in numerous adoptee-related cases, including the constitutional review. Today, I'll be presenting a comparative legal analysis based on a 171-page-long pro bono research paper prepared by 8 attorneys. For the sake of accuracy, I kindly ask for your understanding that I'll present in Korean, and I would be most grateful if adoptees here and online joining us could let us know if you spot any errors in translation. 자, 그럼 발표를 시작하겠습니다. 배부된 토론문은 171페이지에 달한
So the report is as much as 175 pages, and let me touch on the implications. First, I'll start with Sweden. The adoptees over 18 can have access to adoption-related information, and they also provide tracing of birthplace and adoption records. And if biological parents refuse to contact adoptees, the support center provides counseling and psychological support. Next, Denmark. It's a published report saying that there have been legal violations when it comes to inter-country adoption, and it suspended support to inter-country adoption. And just like Sweden, Denmark also provide comprehensive access to their adoption-related information. Next to Norway. When it comes to adoptees over 18 years old, they can request their information to adoption-related agencies and also National Document Agency. And it does not require the biological parent's consent. And Norway is famous for its sufficient support to adoptees, and also it provides inter-country adoption commission, and it provides various support, including translation and phone interpreting funded for first call. And next, once the adoptee become an adult, they can have access to their adoption-related information. However, need decision by court. And next, Ireland. In 2022, it adopted Birth Information and Tracing Act in 2022. And now they are guaranteed with access to their birth and adoption-related information. But it did not happen at once. There have been a lot of different decisions, and we are going to touch on that in depth later. When it comes to Ireland, it provides a tracing service. If biological parents are deceased or they expressed a desire not to be contacted, adoptees still have possibility to meet their biological parents, because through tracing services, all reasonable efforts are made to establish contact. So that's the difference between the Korean system and Irish system. And before the age of 18, their attorneys or legal guardians can make effort to make contact with their biological parents. Just like earlier mentioned parents, if biological parents refuse to make contact with adoptees, the government bodies make effort, and when biological parents do not express their unwillingness to meet adoptees, they can have access to their adoption and birth information. And next to U.S., Alabama and other states in the U.S., they can have access to their adoption-related information, and the state government provides adoption-related information if the adoptees request the information. Finally, Italy. The legal age is a little higher than other countries. There is a youth court that provides information and facilitation. The youth court provide approval, so jurisdictional body take active role in the process. And when it comes to confidential birth, the biological mother is asked whether they want to be contacted by the adoptees. So there are certain processes in Italy. Birth information is an official information, so the adoptees' rights override the rights of privacy of biological parents. Upon the request by adoptees, after private deliberation by the court, within the certain limit of time, the information is disclosed. Next, I'm going to touch on the cases. So let me start with the case in Croatia. And this is a very important case when it comes to adoption case. The right to know the biological parents is very critical. So the holding says that it defines the right to identify as part of the private life and requires timely, effective procedures for establishing paternity relevant to adoptee origin claims. Next, moving on to France. It first identified that applicant adopted after anonymous birth received non-identifying information but could not obtain sibling identities due to mother's anonymity. Next, in Italy, adoptee born anonymously was absolutely barred from identifying data. Violation of Article 8, absolute anonymity without balancing mechanisms violates proportionality. And in 2016, it recognized the right to access their adoption and birth information. The Human Rights Court in Europe enhances the right to origin of adoptees. So referring those cases in European countries, the right to origin of adoptees should be enhanced so they can recover their origin and identity and root of over 2.3 million adoptees around the world should be enhanced. Only when these are recovered, the Koreans living in the country can be happy and wholesome as well. And adoptees should be able to know where they're from, and they never decided which country they be sent to, and that is a very grave violation of equality. Thank you.
Thank you for discussion. Thank you very much. So right now, Imeji has talked about the comparison of 8 countries and what kind of cases came out, and then also giving a very good overview about different litigations and the cases of 8 countries. So lastly, we have Chung Yun-jung, Deputy Director from the Ministry of Health and Welfare. Because of time constraints, if it's okay, could you maybe ask, or we had a question in the first session. Could you answer that first and then also go into your presentation? Hello, everyone. I'm at the Adoption System Improvement Team and improving the disclosure system. So I think that today's event is even more meaningful considering that the system is improving, and thank you very much for inviting me here so that I can talk about my opinion. So the right to origin and how that is actually at the center of maintaining your constitutional right is something that I agree with. And so this system is to secure and to support your constitutional basic right, not to be against it, but to the right to know versus the privacy of the birth parent clash. So there's definitely a conflict that exists. And so how can we harmoniously actually protect the both rights? So the personal information for the private by the birth parent needs consent, and then other information can be disclosed regardless of whether there is consent from the birth parent. But operating this system, there were a lot of limitations and difficulties, which were highlighted by your cases. So the agencies and have been disclosing this information, and there was a discrepancy between the information that was given and what was given and what they have. But the child right, so we'll be transferring all the documentation, and then we'll be able to transfer information, and then we'll have something that is more systematic, streamlined, and make sure that it's more standardized. So, and then you talked about how low the percentage of disclosure information is given. So the information that was given is not correct, and even if it could be falsified. So getting the consent and the procedure to get the consent of the birth parent is very difficult, and then there are some limitations to get their consent because we can't access them. So how can we actually bridge that gap through the procedures and maybe creating more policies? So maybe showing and disclosing information of deceased birth parents, and then those kind of conditions was something that was highlighted by Congresswoman Namisun and other Congress people. So improving that will be on the top of our list. So disclosure of the right to information is something that has been as you've been shared extensively until now. So how the right to information and the right to know of adoptees, how can we expand this further in the future, is definitely how we want to reflect it in our adoption system in the future. And then how can we support it from other agencies. And then language and cultural barriers when you meet your birth families is something that is also difficult. So how can we make sure that we have more personalized and very delicate support for that is something that we've been thinking about. So a follow-up service is something that we've been thinking about, how to cater to the different needs. And we also have Tungji, which is another organization that is specialized in this, will be also taking care of these services. And so not only the Ministry of Welfare, but also the Child Rights organization has been looking at this. And so how can we communicate with Tungji that will be outsourcing this and the NCRC work together more closely in the future and definitely work on those limitations. And support for DNA is something that we want to support. And then how can we also operate and provide more information about how to manage personal data and records. This is something that we've been communicating via NCRC until now. So with experts and adoptees, we definitely need to keep our communication channels and expand them in the future. Thank you. Thank you very much for your comment. So having a more systemized and standardized procedure and have more support so that we can definitely cater to the right to origin in the future. So why don't we give this opportunity to receive questions from the floor? So we had 5 until 5:30 for our discussion. General discussion. So it would be good if we could maybe ask questions, allow questions to be asked. So why don't we receive 3 questions, and then we could also ask the questions that were received beforehand. Okay, so please pass on the mic. We have several hands up. From the middle, please. I ask for your understanding. Currently, we're streaming online right now, so the mic will be given to people that will be asking their question in English.
Thank you for taking my follow-up question. The first thing I want to say is I was so moved by Shin Seung-yup's speech, and I really want to thank you for sharing your deep felt thoughts, and we're all really happy to stand there by you. So it really moved me. I find it a little regrettable on my part that I didn't articulate the reason why I asked my question during the first part of the symposium. And I understand why the panel decided that my question would be most appropriate for the second half. But my reasoning has to do with what I see as perhaps a conflict of interest. If adoptees are expected to write an adoption narrative with documents that they don't have access to, then how will the TRC or perhaps like another independent agency be able to verify that the documents that we receive from the NCRC are in fact our complete file? And I say this on behalf of adoptees that I've spoken to who have gotten redacted files from their Freedom of Information Act. They can't get their files from the agency. They can't get their files from US Immigration. And when they go to the NCRC to get their files, how do we know that we're receiving everything? And I say this from experience because I underscore again, that has nothing to do with consent of my birth parents. It has to do with my birth narrative completely being changed. And so I have to question, why did the NCRC change my birth narrative? Are they trying to protect themselves? It just seems like we need to ask further questions. And I'd be really happy for anyone on the panel, and talk to anybody on the first panel as well with the TRC. How can we ensure that this does not happen and that people get full access, even without the idea of the parental consent, just the narrative, so that we know that we're finding out at least a little bit from our origin stories. Thank you.
예, 질문과 코멘트에 감사드립니다. 아까 그 1부 끝날 때 주셨었던
Thank you for your comment. To elaborate on the question asked during the first session, you have given sufficient answers, but maybe we need more. So if Secretary can make an additional comment, please do so. And the documents were provided with a lot of erasure and deletion. So we have to solve that problem as well. And
네, 감사합니다. 그 영어로 질문을 해야 되는 건가요?
Do I have to ask a question in English? No, you
네.
don't have to.
네,
You can ask a question
안녕하십니까.
in Korean
저는
as
지금
well.
입양 기록 긴급행동 공동대표로 활동하고 있는 신섭입니다. 지금 여러 가지 질문이 있는데요. 첫 번째는 지금 뭐 정보 공개 이제 표준화를 할 것이다 이렇게 정유정 선생님께서 얘기를 하셨는데 그럼 혹시 매뉴얼이 준비되셨는지 지금 9월 16일부터 정보 공개를 다시 시작을 하셔야 되는데 매뉴얼이 혹시 준비되셨는지가 첫 번째 질문이고요. 두 번째가 이제 뭐 그렇죠 민간 입양기관이랑 아동권리보장원이 동시에 하면서 여러 가지 문제점은 많았었죠. 근데 그거는 입양인들이 이제 여태까지 뭐 문제 제기를 안 해서 뭐 계속 지속된 건 아닌 것 같습니다. 그래서 뭐 얘기하셨다시피 작년에도 이제 개선 요구가 나왔었고 뭐 어떻게 뭐 대체적인 어떤 제도를 마련하셨는지에 대한 얘기는 없으셨는데 대신에 이제 뭐 둥지에 뭐 위탁을 했다. 근데 문제점들이 있다. 얘를 얘기를 하셨습니다. 그럼 작년에 저희가 의원님들을 통해서 제도 개선 요구를 했었으면은 지금 제도 개선이 지금 둥지 위탁입니까? 이게 보건복지부가 최선으로 할 수 있는 정책이 이 개선 요구에 대한 어떤 답변이 이 둥지 위탁이라고 생각하면 됩니까? 그리고 계속 어떤 네.
I'm very sorry. Streaming the forum overseas. If you use a microphone, it will overlap with English interpretation. They have difficulty hearing. So please do not use microphone. So commissioning the process to 둥지 entails a lot of problems. So then, until when are you going to keep the status quo? And there are a lot of problems due to
중순 16일부터 다시 이제 시작을 하는 걸로 알고 있는데요. 그때까지 어떤 구체적으로 어떤 변화가 있을지의 개선점들
So how can we make improvements and what expectations can we possibly have?
문제점들에 관해서 그리고 개선점들에 관해서 입양인들과 뭐 소통을 하고 있다 이렇게 얘기를 하셨는데요. 저희는 뭐 많이 만났었죠. 예. 지난 뭐 13일 날에도 뭐 보건복지부와 뭐 NCRC랑 같이 간담회도 했고요. 예, 뭐 협의체를 하겠다. 뭐 기록물 이관 보전 뭐 사후 서비스를 어떻게 할 건지를 협의체를 통해서
We've been talking about what to come up with as procedures afterwards and creating like communication channels. But right now it's already right before September 16th, and the documents need to be transferred. And the establishment of the conversational organization is way too late. So the fact that the organization has been established from Thursday, and we've been multiple times been requesting when is this active, when is the date, and even then they've been asking, oh yeah, recommend an expert until Monday. So the expert that you have recommended needs to be qualified. So when you ask us to believe in you, and you say that you want to create a communication channel, I know that the conversation channel is not closed, and when you ask us to recommend experts, but then you question the qualifications of that expert. I ask you to be brief. So right now at the policy committee, I've heard your stance for the first time. Then will the communication channel organization talk with the policy committee? And it seems like you are currently experiencing a lack of people and personnel. Why do you have two separate organizations? Shouldn't you combine the two? And you said that the committee will all be consisted of adoptees and someone that will represent the adoptee's position. But who will be chosen? Who are you going to appoint? We really haven't talked about that. That hasn't been disclosed. It would be good if you could choose someone that can represent us as a community. Thank you very much for that. And I think this is another question from Chung Min-jung, and this is probably burdensome for you, but why don't we answer get the last question and then answer all those questions.
I'm sorry, I need to ask in English. I'm not supposed to use the mic. Is that right?
No, you can use the mic.
Oh, I can use the mic. Okay. Thank you. I want to make a comment and then ask some question. So it's inspired by, attorney, in your study that you've done, and especially when you reference Ireland, because as far as I know, adoptees have secured through a lot of struggle unqualified access to records. But what I would like to include reference to is that it was a struggle. And right now I'm having a hard time hearing about a constitutional review of our rights to origin or rights to personhood. And part of it is because, in 1957, I wonder if any of you who are sitting up there, do you know how many organizations in Korea were responsible for overseas adoption? And that was extra constitutional. It was not constitutional. Do you know how many? According to presidential records, 482 institutions. And NCRC, you're talking about progress that has been made, and we're having difficulties trusting you with our records transfer. I'm certain that you haven't tracked down 482 institutions that have our records. And I wonder what you're going to do beyond the major four records to ensure that. The second question that I have is, it's a follow-up to a comment that was made earlier in regards to really trying to determine the state's responsibility in terms of determining the extent of forced family separation, the denial of access to our identity, and because it sounds like the TRC unfortunately was not able to do this. But in terms of centralizing our adoptee records, it really needs to include an investigation of the detention centers, all the closed orphanages, these so-called AIDS organizations. For example, there are at least 800 records from the Seventh-day Adventists that were not found from the 1960s. Where have those adoptees been? I believe that is not our responsibility as adoptees to bring our claims to you, to provide our evidence for you, but the state, you should take responsibility and find us. Thank you.
예, 질문에 감사드립니다.
Thank you very much. So about information transfer and then the TRC's responsibility to receive all those documents is another comment that was demanded. So do you have any comments or any answers for that? Can that also be answered by the Ministry of Welfare, Deputy Director Chung In-jung? And then who has the responsibility to ensure that all the documents are transferred and acquired is something that will be answered. So I know that you probably have a lot of questions, but we will answer those questions first, and then those will be answered during the general discussion. And then can we go to the question for the Q&A session? So it would be good if the panelists, Ho-Hae, can actually use the general discussion together. Okay, then we'll receive one more question.
한국말 네 마이크 없이 그냥 해주십시오. 네.
예.
If you're going to speak in Korean, you don't need to use the microphone. So you mentioned information disclosure. That is a very serious issue. So over 7 decades, when it comes to adoption related,
그 전에는 이게 다 흩어졌었어요.
before the documents were all scattered, but now we can have
관할하고 있는 지자체
them in a
공공
single
기록물이
form.
있습니다. 그리고
Before the
마지막으로
local
이제 입양 기간, 그
governments
8세 입양
used
기간이라고
to
하거든요. 그러면 해외
keep those
입양인들은 대부분
records.
자신들의
But
입양 기록을 가지고
inter-country
왔는데
adopters,
그 입양
in
기록에는
most cases,
공통적으로
brought their records.
문제로 드러나고 있는 게 뭐냐면
But
그
what
입양
was common
기록물이
was
이게
the
과연
documents
진실한 것인가, 적법한 절차에
we could
의해서 한
not
것인가부터
track the
자기의
validity
가족이
of
누군가,
those
이 사람이
records,
진짜 엄마인가 안 엄마인가,
whether
아니면
they
진짜 내가
gained those records
부모가 나를 버려가지고 진짜
by
고아가 맞나, 별의별 이게 다 있거든요. 그러나 그 기록으로는 알 수가 없습니다. 그래서 지난 10년
we could
동안
not
체계적으로
check the
한다고 그
validity
NCRC에서
using
기록을
based
하고
on those
있는데
documents.
그 많은 사람들이 놓치고 있는 부분이
What a
뭐냐면
lot of people
지금 입양
miss is
특례법상
that
입양
according to the
그
Special Act
신생
on
부모의
Adoption,
동의를 전제로
without
하고
consent
그
by
입양 정보
biological
공개물을
parents,
신청을 했을 때
if the
연락을
adoptees
하겠다라는 그
request
전제가 들어옵니다.
information
이게 2011년에
disclosure,
그 조항이 들어오는데
in
문제는 뭐냐면
2020, the provision
그거는
was
입양을
added.
적법한
In
절차에 의해 가지고
2011,
보냈을 때의
the
경우에
revision
그게
was made.
했다라는 그 조항인데 사실 지금 그
In fact,
7, 80년대, 60년대
during
이때
the
지금
60s,
와서
70s,
하시는
and
분들은
80s,
그런 것 자체가 적용되는 게 약간 모순점이 있습니다. 제가 한 가지 사례를 단적으로 말씀드리겠습니다. 저도 마찬가지 피해자이고요. 이게 이제 고아우적인데요. 해외 입양인과 국내 그 집단 수용시설에서 퇴소해서 나온 사람들하고 그다음에 국내 입양인 또 장기 실종 그 피해자들하고 다 포괄하고 했을 때 우리가 실종 아동법이라는 게 2004년도에 나와서 국가에서 공적 체계에서 그걸 해주고 있지만 사실 이게 다 법률이 제대로 조화롭게 이루어지지 않고 있어요. 그래서 이게 뭐냐면 일률적으로 76년부터 제가 통계를 잡아왔습니다. 2007년 도호지제가 폐지되기 전까지 1976년부터 이거는 저 법무부 통계 영감으로 제가 조사를 한 건데요. 이게 고아우적이라는 겁니다.
This is
고아우적이
the
뭐냐?
Register of Orphanage. What it means
노
is
레코드, 노 레코드.
parents' record.
그냥 자기 이름만 딸랑 그것도 자기 이름인지 아닌지도 몰라요.
And we don't
지아
even know if
버려진
they
아이라는 그 이름으로 해서
our real
율법상
name or not.
단독 출생하는 그게 이 기아우적이 이게 고아우적입니다. 다 이런 식으로 갔어요. 이게
So
공통점이거든요.
that's what happens here.
그러면
So this is
우리가 뿌리를 알
what's commonly
권리, 그다음에
found.
존엄을 회복할 권리, 이게
The
권리인데
right to
찾을 수가
right to
없어요.
root and right to recover our
기록물
dignity
갖고.
are
그리고
basic right
지금 그동안
to
우리
everyone.
한국의
However,
그
there's no way
입양
we can get
기록물을
access
토대로 해서
to
그거를 제대로 지원을
our
하고 해서 가족 자기의 그 가족을 갖다가 찾을 수가 있어야 되는데
We should be able
매치가 안
to
됩니다.
trace
이
our
진실성이
biological
담보를 할 수가 없어요.
However, we
그래서
cannot
여기에
check the
대한
validity of
일단
these records.
검토가 일단 필요하고요.
So that's
앞으로
why we
TRC
have
3기에서도
to check
굉장히
in
중요한 게 이
the third
기록을
round
토대로
of
해서
TRC.
그거를 갖다가
It must be
이
based
국가의
on
어떤
records.
체계라든가 이런
The
신원에 대한 어떤 그
identity
인권 침해라든가 이런
related
걸 분명할 텐데 그
human
입증받는
right
기록물들이 그 진실성이
will
담보가
be
안
investigated.
되거나 누락이
However, if the
돼버리면
records
어떻게
are
방법이
omitted
없거든요.
or if
그래서
we cannot
실효적이고 구체적으로 할 수 있는 방법이
check the validity
있습니다.
of
바로
those
DNA
records,
매칭입니다.
that's a big problem.
지금
So,
칠레라든가
one
해외의
solution
다른
I'd
많은
like to
국가들이
suggest
해외입양
is
중단
a
선언을
DNA
하고
test.
과거사 진실화해위원회
Chile
이
and many
아동의
other
권리를
countries
하기 위해서
around the world are
이거를
making
국가
effort
단위에서
to
공적 프로그램으로
recover the rights
가족을
of
갖다가
children.
그
So in
존엄을 회복할 수 있는
order
뿌리를 찾을
to
수 있는
help
권리를
them
DNA 매칭 그
trace their
서비스를 통해
root and
가지고
find their own
실질적으로 그
family, they
도와주는
introduced the
그 프로그램을 하고
DNA
있습니다. 그래서
matching programs.
저희는 TRC 3기 때 이것까지
During the
고려해서 할
TRC
필요가
round
있겠다라는
3, I
말씀을
hope
드려봅니다.
that this can be added during the round. Thank you so much.
기록의 진정성
So the validity of the records and the limitations of orphan family register is something that needs to be improved through the DNA matching system was a suggestion that was made. So it's more of a recommendation for the policy to the Ministry of Health and Welfare. So I know that you probably have other questions, but why don't we answer the questions that have come in until now, and then you'll probably have follow-up questions after that. So if you have any follow-up questions, please raise your hands later on. So why don't we go on to Attorney John first? Yes. So adoptees information that they can get for adoption agencies, are they valid or can they be trustworthy, is a question that you've probably asked. So if you receive information, the redacted parts, so this leads to mistrust, right? So without the consent from the birth parents, so all those information that you can actually think, and also the cues and the that you can actually track those birth parents is something that is all redacted. So getting the original documentation is really important. As I mentioned in my presentation, and the system of asking for disclosure. So rather than making it principle to apply for it, it should be changed the other way around. So there should be a particular reason why there can be a reason to say, I don't want to give my information, and that should be the state's responsibility to actually verify or to, this is really against the rights of the adoptees, and if there is a right violation like this, it should be the state's responsibility to actually verify why there should be a reason why the information should be not disclosed. So DNA matching, definitely, I agree with you. That's where the key is. So if we don't have DNA matching, the validity of the documents will be questioned. So definitely adding the DNA will make sure that there is more verification for the documentation. Okay, going on to the answer for the various questions that we received. So we've been talking about why the original documents are not provided. So according to the revision, then it will be the scan of the original document and the digital version will be provided as a principle from now on. So rather than a summarized version, that will be improved for the new revision for the Special Act adoption system. But we will receive consent of whenever for personal information that is related to the birth parent. if we want to disclose personal information about the birth parent. And then you also asked whether how we have created a manual, right? Yes, we're doing the finishing touches for that. And right now for the 16th of September, we'll be publishing it very soon. And then support, and then how we have the reunion support that you've been talking about, and then how we have outsourced this to Tungji organization is something that was, or Morning Family, that is an organization. This is not saying that we're not trying to say we don't have responsibility of this. We thought that we can communicate more closely with adoptees, and this is an organization that is highly specialized in reunions, and so they could actually keep a continuous relationship. And then if you communicate with your birth parents, maybe writing and translating letters so that we can create more rapport, and then also having maybe a translator to support communication when the reunion happens is pretty much why we have outsourced this to Tungji. So this system will be comprehensive and more, and the process will be pretty much from end to end. I think maybe we don't have a lot of trust is because we weren't able to promote it. So promotion about the expertise and what kind of services will be given is something that we need to work on. And then according to Article 12, how can we activate more domestic adoption, and the decision committee will also decide whether inter-country adoption will also be decided. And so currently we are consisting the committee to decide this right now. And with the NCRC, we are communicating how the committee can be consistent. That will be. So this is a different topic with the transfer of documents that will be discussed tomorrow. And we've got your recommendations of who should be the expert. We are currently reviewing it right now, but amongst the experts that were recommended, we have been looking through whether they have been associated with a particular organization or who they've worked with in the past. Those were the questions that we asked because some of their associations or their previous workplaces were not filled out. So I ask you, this is just a misunderstanding. We're not questioning their qualifications.
I think I answered all the questions. Did I miss any questions asked? I think you completed answering all the questions being asked. We're going to take additional questions. Are you going to ask in Korean? And please go ahead without using the microphone.
질문이 마이크를 쓰지 말라고 그러셔가지고. 네네네. 일단 법 관련한 것들 여기
First, when it comes to legislative aspect, since we are gathered with the legal experts today, I think you've made some risky remarks earlier. You earlier said that you were going to submit the document by scanning the original. Do you know about the ordinance? The ordinance stipulates how to provide those documents. We scan the original copy and we can provide them as digital copy or paper copy, or we can allow the
1번 비전자 문서의 형태일 때는 문서에 열람을 요청할 수도 있고 원본을 봐야 되는 거죠. 육안으로. 그리고 아니면 사본을 제공할 수 있다라고
refer the original copy.
그런데 이 지금 문제가 된 이유가 뭐냐면요. 임시서고가 냉동 물류창고로 정해지면서 그래서 사실 입양인들이 여름 내내 땡볕에서 시위를 했는데요. 그 결과로 임시서고 방문 협의체라는 것이 간신히 만들어진 겁니다. 단 한 번도 보건복지부나 아동권리보좌원에서 수없이 메일을 보냈지만 만나지 않고 답변이 온 적이 없습니다. 수없는 연락을 통해서 간신히 만들어졌는데 그 과정도 신 대표가 지금 잠시 얘기했듯이 아주 무책임한 일정으로 진행되고 있습니다. 목요일 예를 들어 예정인데 전문가를 우리에게 다 준비해라. 그리고 월요일 날 그거를 잘 알려달라. 그러고 나서 화요일 날 그 사람이 부적절하다. 누구 어떻게 만날 수 있습니까? 그럼 보건복지부에 생각하는 전문가들을 알려달라. 노답. 이런 상태에서 그럼 다음 협의체 이후의 일정은 어떻게 되냐? 1년에 4번 만나자. 지금 문서고 문제가 하나도 해결이 안 되는데요. 스프링클러가 돌아서 문서가 다 화재가 나면 젖을 것 같고 열람실이 하나밖에 없고 그리고 장애인은 접근이 불가능한 위치에 장애인 화장실도 없는 곳이기 때문에 원본을 도대체 어떻게 볼 수 있습니까? 그랬더니 서울에서 갖다 보여드리겠습니다. 어떻게 그러면 기록물을 위반할 수 있습니까? 입양인들과 협의하겠습니다. 그랬더니 갑자기 선언하신 거죠. 저희는 스캔을 제공하겠습니다. 앞에 문제가 하나도 해결이 안 됐는데요.
But without
시행령에는
resolving the
분명히
issues
문서에 열람을 할
aforementioned,
수 있는 입양인들의 권리가 써 있습니다.
in the
그것은
ordinance,
임의로 보건복지부나
the
아동권리
ordinance
보장안에서 저희는
stipulates
스캔을
the right
제공하겠습니다라고
to
선심 쓰면서 얘기하실 얘기가
access
아니에요.
to
시행령을
those
어기고
documents
계시고
and copies,
시행령이
but
불가능한
now you are
조건을
saying that you
임시서고에서
are going
지금
to scan those
기록을 다
documents
이관하고 계신
and
겁니다.
provide them.
그 과정에 대해서 지난한 과정에 대해서
now
다 얘기할
you
필요가 없고
are,
또 하나 위험한 건 법에 대해서 얘기하자면
also
둥지라는
saying
곳에
that
상봉 서비스를 하기 위한 근거가 도대체 법에 어디 있습니까? 시행령에는 위탁할 수 있는 사업 내용이 정해져 있습니다. 그것은 양부모에 대한 심사 그리고 사후 관리, 입양이 된 아동이 잘 지내고 있는지 이 부분만 위탁할 수 있다고 아예 시행령에 규정이 되어 있습니다. 그런데 친부모가 만나서 입양인들하고 소통하는 그 중요한 자리 그거는 아동권리 보장원이 준비했어야 되는 일이죠. 당연히 그걸 개인정보를 넘겨가면서 제가 지금 입양인 친구 때문에 신청도 해봤거든요. 주말에는 저희 서비스 안 합니다. 지방은 어렵습니다. 그리고 나오는 분들은 다 자원봉사 통역자예요. 입양 백그라운드에 대해서 전혀 모르시는 그분들한테 신청할 때도 친모 개인정보 동의하는 거 이메일로 보내주십시오. 얼마나 그게 프라이빗한 자료인데요. 누가 이용할 수 있어요? 거기다가 저희는 예산이 제한돼 있어서 예산 범위 안에서만 서비스합니다. 그러면 1년에 100케이스, 200케이스 하면 그럼 순서대로 선착순으로 서비스하는 거예요. 근데 이 모든 게 시행령에 없는 내용이란 말이에요. 어떻게 임의로 그거를 결정하시고 우리는 입양인들을 위해서 이런 일을 한다고 선심 쓰이시 얘기하실 수가 있냐면 법을 도대체 공부를 하십니까? 그 헌법 얘기 오늘 너무 많이 했죠. 아까 그 임예지 변호사님이
constitutional law have been discussed so many times. The paradise earlier presented by attorney Im, I felt that it's
물론
unrealistic.
친모가 어떤 사정이 있는지 과거에 어떤
We do not know
우리나라의
the past history and
미혼모에 대한
what
어떤
kind
나중에
of story the
그런 것들 다
birth mother has.
감안하더라도 지금 법은
But even after considering all that,
개정한 거를 절대 자랑한 일이 아닙니다.
but
법이
revision of
허술했어요.
the law
이제는
isn't enough.
친부모가 동의하지 않는
Without
경우만이 아니라
consent of biological
친부모의 동의가
parents,
확인되지 않은 경우에도 정보를 공개하지 않도록
the
법이
information
허탈을
won't be
했습니다.
disclosed.
왜? 아동권리
if
보장원의
the
업무 편의를 위해서
parents
연락 안 되면 계속
do
연락해달라고
not consent
부르니까요.
to provide
입양인들이
information,
이런
but
거에
if
대해서
we cannot get response
알고
from them, the
계십니까?
information will not be disclosed. So the law actually retreated.
인권위원회 지금 진정 올라가 있는 거 알고 계시죠?
So do you know the complaint has been filed in the Human Rights Commission?
3달 동안 정보 공개 청구를
3
중단을
months.
임의로 할 수 있습니까? 아무리 기본권을 제한하려고 해도
Information
소송의
disclosure
원칙, 이런 거
service
있지 않습니까?
has been arbitrarily
그런 거
suspended.
하나도 지키지 않고 임의로 중단하고
The service
거기다가
was
입양 확인서
arbitrarily
DNA 검사하는
suspended,
것까지 다 막아놓고
and DNA
이게
testing
정보
has been stopped. I don't understand why this happens. You don't work properly. The transfer has been delayed so many times. The reason is that you do not have enough staffing. The transfer team and information disclosure team has the same number of staff. And who takes the responsibility? You get all the work, but without human resource, the work cannot be done.
신청한 사람 절반이 정보공개
I cannot
서비스
understand
신청 웹페이지에 신청을 하면
when
자기
we
아이디가 없어집니다.
get
웹페이지에 이런 치명적인
file
요구가 있는 거를
application on the
보고는
website,
아동권리보장원 알고 계십니다.
the ID just
이게
disappear.
중앙당원 때 만들었던 시스템이에요. 그래서 신청을 하면 자기 비밀번호로 자기가 접속이 안 돼. 50%가
The 50% of applicants can have access to the website with their ID and password.
이메일을 1년씩, 2년씩 답변을 안 합니다.
The emails are not checked for a year or even for 2 years. We are not asking for something ideal. We just want the law to be complied. It's not legally binding. And that's the priority for us. Constitution is good, and the routine requests cannot be done because their ID of the website just disappeared. That is why they filed complaints to the Human Rights Commission. I'm not sure if they are still valid because a lot of time has passed.
Thank you very much for your comment, understanding the reality of adoptees. And the limitations of the current policies is something that we all have responsibility for. And so as someone that is currently studying family law, I'm definitely responsible for the limitations of the current law. And so storing the documentation in the refrigerated facilities, outsourcing to Jungji, not allowing DNA tracking, and the lack of resources is also led and caused because the lack of budget. And the budget can be solved by the National Assembly, and that's why we're currently holding today's forum at the National Assembly. I hope that our voices are heard. Yes, the Ministry of Health and Welfare will definitely look to support this more appropriately, and if there are any applications, making sure that this will pass and making sure that your voices will be passed on. So I would like to thank everyone for staying till the very end during today's forum, and everyone that is currently accessing on the online platform. Thank you very much for your time and your vital feedback. Shouldn't our questions be answered? Because of time constraint, I ask you to answer it very shortly as possible. Yes, thank you. Right now we have a budget that is dedicated for the after service. This is for, according to Article 6, according to the revised Adoption Act, and then according to Child Rights Act, the Ministry of Welfare. So the Minister of the Ministry of Welfare can actually appoint an agency that will do this, and that's why we can actually entrust a private entity to do so. And all these, that's why we have chosen the most appropriate agency, and such as Jungji. And we will, of course, monitor very closely about how they're carrying this out. And then, as Shin Seung-yup CEO also mentioned, making sure that there are no limitations for the service because of budget is something that we will definitely communicate much more closely with adoptees in the future. And our communication channels will be something that we'll work on to make sure that we minimize any misunderstandings. making sure that the process and the application is effective. And then having access to documentation. The applicant that accesses documents, making sure that they can actually have access to it through the method that they prefer, whether it's electric or PDF or for the format they are asking. So making sure that they have access to this document. So you can actually access it through the digital copy of the original. But if you want to see the original, you can come to the storage facility. And based on the consent of the birth parent, we will have to only show the information that is not related to the personal data of the birth parent. And that personal information can be deducted, and that's why it does take more time. So scanning the original file first, and then if there are any personal information that needs to be de-identified or deducted, yes, you can get access immediately if you apply. And about the transfer schedule, we do have a specialized transportation company that is currently working. This will not be delayed because the lack of personnel. And for monitoring, we currently have the NCRC and the Ministry of Health and Welfare that is currently overseeing this, and so getting support from other departments to make sure that there are no delays. So the transfer of documents project is currently being carried out without delay. So moderator, do we have any time to extend the general discussion? So we've already passed the designated time. Maybe we can receive one last question. Okay. One last question from.
Are you going to ask the question in English? Please pass the microphone.
Okay, thank you again for taking my comment. I feel like I have to be a little bit more specific about the private information that was not released in my NCRC document, because I feel like there's a bit defensiveness. This document had nothing to do with my parents' consent. Actually, the agency never got my parents' consent, but this document had to do with my birth narrative. Specifically, and this was very private, my parents were married when I was born. This was completely omitted. And by the way, when I got my information from NCRC, I got every single scanned document except for this one. So then you question, why was this omitted from my documents? And I say this not for me, but I say this for other adoptees who haven't gotten their documents yet. I'm only in this position because I got my documents already in the 1990s. So what, can you explain, please? Why is there a discrepancy between what I received from the adoption agency, what I received from, as well, from US Immigration, which have different documents, and what I received from NCRC? I would like that question answered. And if you cannot answer that question, I would like you to investigate why there was a discrepancy. Thank you.
예, 감사합니다.
Thank you. When it comes to your private information, other information has been omitted and you made the issue out of it. Each case cannot be answered today, but later, if they can be procedures taken afterward, we are going to do that. We are behind the schedule. Since you haven't made any comments, you will make comment. I'll keep my remarks short.
라는 방송에서 말이
There is a TV show called The Street, and Mary Kim said that I'm part of my mother. Why I cannot have access to information and documents about my family? And I asked NCRC if I can have DNA testing. They answered that since I'm not a missing child, I cannot have that either.
입양인 2세에 대해서 아동 권리 보장원에서 공식적으로 반박을 했다고 들었습니다.
And she was not adopting herself, so she was denied the right to have access.
거부가 아니었기 때문에
And the information was not given, and it wasn't not equivalent to denial.
그리고 굉장히 최근 일이었습니다.
It was very recent.
제가 하는 건 질문이 아니고요.
It's not a
저는 이런
question.
식으로 자기의 부모를 위해서 싸우는 입양인
There are a lot of second generation of adoptees, and they are being attacked, and it should be openly discussed.
입양인 2세들에
The
대해서
second generation of
외국인인
adoptees
저에 대해서도
are not
명예훼손
being
소송
respected,
등으로 불만을 제기하실 수
and
있을 거고요.
I
저에게
think
입양인이나
I
입양인
can be
2세들에
legally
가했던
attacked
공격을 하신다면
by
저는
defamation
조용하지
litigation,
않게
but
응대를
I will
할
not
것이라는
keep
말씀을 드리고
silence
싶어서 발언을
if
드렸습니다.
I am
감사합니다.
not being respected properly. Thank you for your comment. We are going to reflect your comments and questions when it comes to malpractice of information disclosure. Now we really have to wrap up and close the event. Once again, thank you for your patience. Thank you.
예, 준비.
Thank you for everyone that made today's platform possible. And I ask for understanding. We did receive some questions beforehand, but we weren't able to answer them and go through them because we were kind of busy answering the questions received from the floor. Thank you, everyone. See you next time.